kicking off with her bill, Senate Bill 159, which is health occupations, authorized prescribers, reporting of financial gratuities or incentives. Madam Chair, welcome back to EHE. You are still muted, Madam Chair. We are having some problems. As I said, we've got someone, it's probably at our end, Madam Chair. Let's see, is it Tanya? Can we get some help with unmuting Senator Kelly, please?
Maybe it's in the set, like the bottom.
We need Lemuria back. She's not allowed to take time off until May. Madam Chair, I think it's not at your end. I think it's at our end. You're not doing anything wrong. I hope you can hear me. Chair Kelly, I think the problem is here in EHE. Yes. So Senator Bidle is saying that that the committee has to unmute, and Senator Bidle, that is what we are working on her doing. It should work now. Do you want to try, Chair Kelly? There, oh, we almost had you. I think you're. There you go. All right.
Okay. Thank you.
We are working here. So Senator Kelly.
We'll all be glad when these days are over and we go back in person.
No kidding. Well, welcome to EHE. Sorry about that glitch.
Sure. I appreciate this opportunity to testify on Senate Bill 159 regarding health occupations, authorized prescribers reporting of financial gratuities or incentives. Senate Bill 159 requires specified categories of authorized prescribers of drugs and devices to give private but timely notice to their respective health occupation boards whenever the authorized prescriber accepts a financial gratuity or incentive in exchange for the promotion of products or services. This bill includes a list of 10 common forms of gratuities which manufacturers of drugs and medical devices commonly offer to promote their new products or devices. Senate Bill 159 takes no position on any of the particular offers or on the acceptance of a gratuity, but directs Maryland's various health occupation boards to develop regulations for systematic and private review of gratuity notifications required to be submitted to the appropriate health occupation board in each instance. The point of Senate Bill 159 is to empower Maryland health occupation boards to develop regulations which ensure systematic, private review, as well as appropriate responses to required notifications of gratuities already accepted by any of each board's roster of authorized prescribers. The bill sponsors and members of this important Senate committee recognize that not all offers of gratuities are equal. The sponsors of Senate Bill 159 hope that highlighting the superfluous amounts which some, but not all healthcare providers have accepted from either drug companies or from manufacturers will be on record with the appropriate health occupation board, which can privately evaluate such notice so that where questionable, the Occupation Board can take appropriate action as per its regulatory oversight. While there is a national database requirement of relevance in the US, see section 1128G, USC 421320S7H. A transparency report, the resulting undocumented, that relevant document is too massive. It's hundreds of thousands of entries. I've been looking at it for about 10 or 11 years. It's not useful when if an occupation board or a member of the public or a colleague to a professional colleague were concerned that maybe there is a financial incentive or some other incentive that should not be there, that they would need to look at hundreds of thousands of entries. And of course, this database, which is national and which is referenced in the written testimony, which I was glad to receive from MedChi, that they approved the bill, but with an amendment. They think that we ought to go to this national database. There are two problems with doing that. One is that we are concerned about all health occupations that are able to prescribe devices or prescriptions and not just physicians. And secondly, we are aware that this database is so broad that you could spend a month doing nothing but looking for one physician's name because it's a nationwide database. And you're looking not for anything in particular because not everybody is even accepting gratuities. The public reporting required by Senate Bill 159 would be Maryland specific and would be a private report submitted only when applicable to the occupational board for each category of healthcare providers. Attached to my written testimony are 4 very enlightening news articles which illustrate over the years the excessive and unnecessary costs which result when healthcare practitioners accept unwarranted gratuities from manufacturers of medical hardware and/or from drug manufacturers. One of the articles, Doctors Net Billions from Drug Firms, a Wall Street Journal article, goes back to 2014. People have been looking at this and concerned about it for a while. The second article, the AMA Code of Medical Ethics, Opinions on Physicians' Relationships with Drug Companies and Duty to Assist in Containing Drug Costs. That's in Virtual Mentor, American Medical Association Journal of Ethics, also 214. Then there's a local hospital doctor named in lawsuit over fake surgical hardware, the Baltimore Sun, 2015. Then the fourth article I've appended is Dollars for Doctors, ProPublica, at October 17, 2019 article. In light of all of these considerations and in light of the fact that physicians are only one of the many professions that are healthcare oriented that we are concerned about because there are prescriptions being written and dispersed by all of them. Secondly, we don't expect that most people will ever be a problem, and we don't want our occupational boards or the physicians board to need to spend hundreds of thousands of dollars a year and hire staff just to look up names because there's nothing happening that is amiss in the cases of most practitioners. And it's kind of a waste of funds to do it that way. So in light of all of these considerations, I humbly ask for your expeditious support of Senate Bill 159 with my amendment to add Senator Joanne Benson as a co-sponsor. Thank you very much. I'll take any questions that you might have.
Thank you so much, Madam Chair. Just so you know, in the middle of your testimony, your face went away. And we love
Oh,
to see
wow.
your smile if you are inclined to show that to us as we welcome your witnesses. So Patricia
Yeah.
O'Connor from the Maryland office of our wonderful Attorney
Okay.
General, Health, Education, and Advocacy Unit. Ms. O'Connor, are you with us?
I am.
Yes.
Can you see me?
I sure can. Welcome to EHE. You may begin, and as lead witness, you have up to 5 minutes.
Thank you so much. Good afternoon, Chair, Vice Chair, members of the committee. I'm Pat O'Connor from the Office of the Attorney General's Health, Education, and Advocacy Unit. I'm here today in support of Senate Bill 159, and we wish to thank Senator Kelly and the co-sponsors for this good bill. We believe this bill would provide a targeted tool that can be used by the health occupations boards in Maryland to have information that is specific and actionable with regard to whether the reports to be submitted by the prescribers fall within the prohibitions of various laws we already have on the books. There are anti-kickback laws, federal and state. There are self-referral laws, criminal and civil. With this targeted information, we believe, for the first time, there could be a more robust audit, investigation, and potentially disciplinary proceedings of those who submit the reports if they fall within the prohibitions under existing laws. We honestly don't expect there to be a lot of reports because we believe, we hope that there is not a great deal of this activity occurring among our licensees, but we simply don't know. And it is useful to have the open payments database, which is a federal database that the boards could use to verify and check the reports submitted to them. We're all concerned about increasing drug prices. We believe that there may be a contributing factor to be found in the conduct of some prescribers who may or may not even be aware of it, given the nature of bias and conflict of interest. So we see this as an important tool that may serve simply as a prompt when prescribers are informed of this, when they understand that they will need to report those financial gratuities and incentives that match up with the bill's definition. They may rethink whether they wish to accept it or to continue accepting it. And we believe that's good for the marketplace. We think it's good for providers and the trust that the public wishes to have in its providers. I'm happy to answer any questions the committee may have.
Thank you very much, Ms. O'Connor, and thank you for the work you do for the residents of Maryland every day. We all appreciate you.
Thank you. Happy to do it.
Thank you. Favorable with amendment, we have Steve Wise representing MedChi, our doctors. Mr. Wise, welcome back to EHE.
Thank you, Vice Chairman Kagan and members of the committee. Speaking on behalf of MedChi and the College of Emergency Physicians, bear with me because I think when I first start talking, you're going to think I'm opposed to the bill. But we have an amendment which I think, in our view anyway, tries to partially meet the goal of the sponsor. You have our written testimony, so I'll refer you to that. But the principal problem we have with the bill is that the reporting that is required here is already done at the federal level. So every drug manufacturer in the country has to file reports, and those go into a federal database, which we provided a link to. You can punch in any physician's name. I went and did it myself. And you will see everything above $11 or more that they have received in value from a drug manufacturer. So in terms of the data being out there, it's already there. To require physicians to have to report it again, we see as completely needless. The second part of this is, okay, it's out there. Can the Board of Physicians take action on it? If they get a complaint, for example, that Dr. Smith is prescribing a certain drug and getting tens of thousands of dollars from the manufacturer of that drug? The answer to that is 100% yes. As we sit here today, there are at least 2 and maybe 3 grounds in the Board of Physicians statute under which they could pursue that doctor. So you have the information there and you have the grounds already available to go after that doctor. Now to the amendment, which we're trying to help with the public accessibility of this. Right now on the board's website, every Maryland doctor has a profile: education, discipline, malpractice insurance. It may make things easier for Maryland consumers to be able to go there and provide a link to the federal database. But that gets us away from a second set of reports of the same information. I think the board is open to that. We're certainly open to that. We're not trying to hide the information. It's out there now, but we don't see a need for already overburdened physicians to have to report the information a second time. As to other providers, I can't speak to them, but I believe they were added to the federal law recently. But I'll let them address that, and I'm happy to answer any questions.
Thank you, Mr. Wise. Colleagues, I see no questions.
Hold it.
Okay, Senator Ellis has a question. Oh, and so does the chair. Okay, Senator Ellis.
Thank you, Madam Vice Chair, and thank you, Senator Kelly, Chair Kelly, for this bill. I too was always concerned with what I read. And so my question is, okay, you have this reporting requirement. What will be the enforcement? Is there enforcement tied to this? I think Mr. O'Connor maybe alluded to that, but could you elaborate on that?
Yes. Senator Kelly, would you like me to respond? So Senator Ellis, we foresee the boards through their audit, investigation, and disciplinary authority and actions being able to fit this information into the web of Maryland and federal laws that are already on the books and are intended to inhibit or prohibit the acceptance of gratuities or financial incentives that fall within the bounds of the prohibited behavior. So this will be solely within the province of the board. The public will have no access. And the law foresees us relying on the subject matter expertise of the board staff and their investigators, and using this information in a targeted, efficient way. We think it's a great idea.
Yeah, and so thank you for that. So
Just go ahead. Okay.
currently you have, well, I shouldn't say currently, but in the past, there are various ways of providing incentives to medical professionals. Could be trips or vacations or consultant fees or so when you say gratuities, is it does any kind of payment in that area covered also for disclosure?
Potentially, yes. So the bill speaks of a thing of value in exchange for the promotion or purchase of products or services. The bill further specifies what is included, which is not exclusive, but it does itemize things such as cash payments, speaking agreements, consulting agreements, physician ownership agreements, stock option agreements, research grants, clinical trial agreements, and conference attendance.
Okay.
So it will be that information that then the respective boards will develop the facts surrounding it, and then the analysis as to whether what is being reported requires action.
Thank you.
Thank you, Senator Ellis. Mr. Chairman?
Thank you, Madam Vice Chair. Let me start with a question for Mr. Wise. On the national database you referred to and are suggesting we utilize, is that data submitted by the companies or by the doctors?
That's submitted by the companies.
And how confident are we that they are submitting data in all those categories?
That's obviously the obligation is put on them under the federal law. I can't say that I've gone and looked for compliance audits on that, but if you go in and you pull up a doctor, I mean, you're going to see things for like $12.10. So
I've done that.
yeah. So, I mean, I think it's pretty comprehensive.
Okay. And to either the sponsor or her witness from the Attorney General's office, was there any thought, while the boards can take action if there's over prescribing, clearly reviewing if this bill were to pass and that database is created, reviewing that database for a correlation between potentially oversubscribing and getting significant amounts of money might be provide some good indicators. So was there any thought to sort of marrying the two, of having the board utilizing the database? I mean, it's not a causal effect, but if someone's receiving $50,000 or $100,000, and while they might not be off the radar screen, they're getting close to being off the radar screen, that might be some data, maybe not evidence, but data towards some untoward activities.
Our expert from the Attorney General's office might be able to give you a more technical answer than I would. But in the first place, right now, no other health occupation other than physicians really are required to be in the major database that we're talking about. And you've got all of these other prescribers. And so everybody would be treated similarly, and their own health occupation board would privately receive the documentation that they provide and deal with them if something needs to be dealt with. If there's nothing to deal with, it's just there. That's really the idea.
Ms. O'Connor, anything to add or not?
If I understand correctly, Chair Pinsky, are you talking about the cross-checking function? And
Yes.
that is exactly what this bill intends to provide for in a targeted, efficient way. And so upon receipt of the reports, the licensing boards, which have authority only over the licensees, not the pharmaceutical manufacturers or distributors who submit to this massive federal database. It is their licensees over whom they have authority. And a lot of this may involve education of those who are close to the line. It may involve something more for the egregious cases if they exist. So we certainly, and speaking with the sponsor, we see it as a strength that these targeted reports can then be cross-checked by the board and its staff against the massive federal database.
Thank you. And I'd only conclude by saying I've recently completed reading Empire of Pain about the Sacklers and Oxycontin, which was an abomination. The book was excellent in terms of what happened, transpired in this country for over 10 years with hundreds of thousands of people who got addicted because of it, and them just buying their way into doctors' offices with lots of money and other financial remuneration. Isn't that so? Thank you, Madam Chair.
Thank you.
Thank you, Mr. Chair. Thank you.
Sorry about that.
You're good.
You just missed all the great things I said about the chair and Chair Kelly. Thank you.
Go ahead. You're unmuted. Go ahead.
Thank you. Thank you for this bill and always putting us in the right direction. This question is for Mr. Wise. So I just plopped in and into the federal database, and I typed in the name of a doctor. And the particular doctor this is to your point about that this is a burden. And I just see two entries. Looks like, one company spent $80 on a meal or something with him. That's some meal. And then there's another that's a gift, but it's in this category of food and beverage. Also, you have to put in, as a lobbyist, or that I shouldn't say you, lobbyists also have to do reports. And then we also have to say what we are doing. And then there's a marrying between the two. So I guess I don't see the amount of time, and I guess I want to further understand, why would you say that it takes a lot of time when I just see a couple of things there?
So as I recall in the bill, the reports are required, I believe, on a monthly basis. Don't hold me to that, but I'm pretty sure of that. You're going to have, so I mean, picture a family practice, okay, that the drug rep comes in, buys a $12 lunch. They're going to now be filing a monthly report, which, unless somebody has presented evidence otherwise, is supposed to be on the federal website. So that family practice, which is doing many other things that I think we're all familiar with right now, has now got to file a report for data that is already going to be there. And that's what we just don't see the point in.
If I could butt in, there is no requirement in the bill as to how often that on a monthly basis anything would be done. It's only when you have accepted something, and it's only to your occupational board. And remember, this includes all of the healthcare major occupations and not just physicians. So if you aren't accepting anything, if you are, it just goes in the file in the board. If it's something minimal, it's something that would make sense. They treated you to lunch, you spoke somewhere or something.
Yeah, thank you. Thank you.
The boards are required to develop regulations in each case, each board, as to how they're going to handle this.
Yeah, and then also, I think the other issue, Mr. Wise, is that you're putting the burden of analysis and searching, et cetera, on the patient and the user. And you know well that that's just not going to happen. And so it'd be much easier, if there's a report that's put out that is being analyzed and put together by the board, and they're doing that work, for them. So that's all. I wanted to see if it looked like a very complicated thing. And this is a very high level doctor, and he just has like two entries for the whole of 2020. So it's not a lot. So thank you, Madam Chair, and thank you for your answer, Mr. Wise.
Thank you, Senator Washington. I see no other hands up, so we can thank the Finance Chair, Senator Kelly, and you can go back to Finance, and I will join you there a little later today.
Thank you.
Thank you for the bill. That completes the hearing on Senate Bill 159. Colleagues, let me run through, since now most of us are here. Let me just go through the order in case anyone in the room or colleagues want to know the order. The next bills are going to be Senate Bill 386 and 440, both by Senator Beidel. Then we'll go up to Senate Bill 154 with Senator Eckert and work our way down in numerical order unless something funky comes up and someone is unavailable. So that is our plan. And before we jump back into hearings, I just want to recognize that our wonderful colleague and committee mate, Senator Gallion, is celebrating his birthday by sitting here all afternoon in hearings and then a voting session. So we're glad you're here. Thank you, Senator Gallion.
Thank you, Madam Vice Chair. My staff just brought me cake. I had to turn my camera off momentarily. If we would have had a little more, we'd have had for the whole committee, but unfortunately we're remote. So
I was just going to say, I'm not going to say so many nice things about you if you don't share your cake, but that's all right. All right. Senator Beidel, welcome to EHE. We're glad you're here. And we're going to start with Senate Bill 386, Interstate Medical Licensure Compact, Sunset Extension and Reporting. And there are no sponsor witnesses, but we do have a couple of people who are signed up to testify, but we are kicking off with you. So you may begin, Senator Beidel.
Thank you, Madam Vice Chair, and good afternoon, Chair Pinsky and members of the Education, Health, and Environmental Affairs Committee. Senate Bill 386 is the Interstate Medical Licensure Compact, and it's a sunset extension. And I just want to mention that there was an amendment put on in the House, and it's already passed out of the House with the amendment. So you do have the amendment in committee. It's 833229/1. So the little background, in 2018, legislation was passed that allowed Maryland to opt into the Interstate Medical Licensure Compact, thus the licensure process to allow physicians to become licensed in multiple states was streamlined and expedited. And at that time, 22 states were part of the compact. Now it's 26 states. The compact has helped physicians expand the use of telemedicine, which has proved essential during this recent pandemic. And without the compact, Marylanders, especially in rural areas, can lack the necessary care they need and often face longer wait times and further travel to physicians. So Senate Bill 386 accomplishes two things. It extends the termination date of the Interstate Medical Licensure Compact, and by the amendment, it extends it to 2027. And it expands among the annual report the State Board of Physicians is required to submit under 14205.1 of the Health Occupations article to allow for more transparency and accountability, making sure the compact is accomplishing what it's intended to do. As I said, the crossfire has already passed, and I would respectfully request a favorable report on Senate Bill 386 with the amendment. Thank you.
Thank you, Senator Beidle. Because there's no chosen witness by you, that means those testifying will each only get 2.5 minutes. And we're going to hear first from the Maryland Hospital Association. Erin Dorian, you have up to 2.5 minutes. Welcome to EHE.
Thank you, Madam Vice Chair and members of the committee. I really don't need that much time. I want to say that the MHA was a strong supporter of the compact when it was first passed, and we continue to support the compact. We believe it is working and should continue. And then the amendment added at the request of the Board of Physicians by the House is just a good government amendment. It extends the compact to their sunset extension to align those two processes. So it all can be done at once their sunset extension comes up, and we strongly support the compact. With that, I ask for a favorable report.
Thank you for your brevity, Ms. Dorian, and thank you for your time. As I said earlier, this is the last time you can show up on your computer and stuff. So next week, we'll see everybody in person. Steve Wise, you're up next from MedChi and the long acronym group.
Yes, the emergency physicians will go with MedChi and emergency physicians. Thank you, Senator Beidle, for putting the bill in. The compact has been a very useful tool for us, so I second everything that she said and Ms. Dorian said. The one thing I'll add that hasn't been said is under the compact, the advantage is that physician gets a license issued by the Maryland board. And because of that, they're subject to the jurisdiction of the board, the discipline of the board, and they can have their license revoked by the board. So we've retained licensure here, but we've made it easy for people to go among multiple states. So it's an excellent tool, and extending it to 2030, I think is what the amendment is. We're fully supportive of. Thank you.
Thank you, Mr. Wise. And Matt Dudzik, you are next with the Board of Physicians as well. Mr. Dudzik.
Good afternoon, and thank you for hearing me, and thank you to Senator Beidle for submitting this bill. The Board of Physicians doesn't have a lot to add. I'm sorry, Matthew Dudzik, on behalf of the Board of Physicians, for the record. Board of Physicians doesn't have a lot to add. We have been strong supporters of the Interstate Medical Licensure Compact. In fact, our executive director was actually recently elected to vice chair of the compact. We believe it's just a very important tool for ensuring that there are, multiple licensure pathways for physicians in Maryland. We have already incorporated the necessary operational changes to make sure that we can quickly and adequately license folks through the compact. We'd like to see more states get involved. Again, we do support the amendment to align the sunset of the compact with the sunset of the board. We think that just makes sense. It allows us to kind of combine some of the reporting requirements. But we urge the committee to submit a favorable report. Thank you.
Madam Vice Chair, if I can add.
Please, Senator.
Thank you. Mr. Wise was absolutely right. Initially, it was going to be 2027. And it was substituted by amendment to June 30, 2030. So as always, Mr. Wise knew better. Thank you.
Are you saying that Mr. Wise is wise?
I am.
Yeah. let's not get that too far on the record. All right.
Let's not inflate his ego more than it is.
There's that, exactly. I see no questions from colleagues. Therefore, that completes the bill hearing on Senate Bill 386. The next bill is also a Senator Beidle bill, Senate Bill 440. Commission to Study the Healthcare Workforce Crisis in Maryland established. Senator Beidel, you may begin.
Thank you very much, Madam Vice Chair, and to Chair Pinsky and the members of the Education, Health, and Environment Committee. As you all know, we have a real shortage in Maryland of healthcare workers, and it's just been exacerbated by this COVID pandemic, but it is very, very serious. So this is a crosswalk of a House bill. It I think is Delegate Ariana Kelly's bill in the House, and it sets up a commission to really study the current shortage as well as future shortages of what we see in healthcare. There is some really kind of scary numbers about we expect 500,000 more nurses to leave the workforce this year in the US, and bringing the national shortage to 1.1 million nurses. We have, I don't know if you're aware, but we have huge shortages in our Maryland hospitals, and some hospitals are paying agency nurses, paying the agency $200 an hour to be there and staff, particularly ICUs where the pandemic, the patients with the pandemic are really being treated. So I'm not going to go into a great deal of detail. You can read the bill. The commission is a number of deputy secretaries and secretaries that need to be included. There's been a widespread interest, and a lot of groups wanted to be added. The recommendation is that these groups will be added by in work groups, because if you get a commission too large, it becomes very kind of unwieldy and difficult to get decisions made. So we're hearing from the community colleges and different work groups that they want to be added, and the suggestion is that they'll be added by work group and not just to the entire commission. So it's an important bill as we look for the future of our healthcare workforce in all areas, not just nurses. We have shortages in physical therapists and LPNs and OTs and PTs. It's a really serious healthcare shortage coming. So I hope that we can support the bill. I'd like your favorable support. Thank you.
Thank you very much, Senator Beidel. Again, Senator Beidel doesn't have her own witnesses, so I'm going to go down in the order in which you signed up. We're going to ask you, we have one unfavorable witness, so we're just going to ask you to be additive and not redundant. And if you can also try to watch for acronyms and try to avoid them, since we don't always hear. Okay, I was muted. All right. Hope you heard most of what I just said. In any case, so the next witness, Dana Kaufman, Lifespan Hospice and Palliative Care Network of Maryland. Ms. Kaufman, welcome to EHE.
Thank you, Chair Kagan, members of the committee. For the record, my name is Dana Kaufman. I'm here on behalf of Lifespan Network, the Maryland National Capital Home Care Association, and the Hospice and Palliative Care Network. All three organizations do support the bill. I don't need to go into too many statistics. You are all very much aware that the healthcare workers crisis that we are operating under in now, but I also want to make the point that the COVID-19 pandemic exacerbated it, but we were already under a healthcare crisis, especially in long-term care. So we do think that this commission is very timely to tackle these very complicated issues regarding recruiting, but also just thinking outside the box on what we need to do educational wise to try to incentivize and make it easier for individuals to be able to get the training that they need. I'm going to add just one point, and it's not per se needed to go into this bill, but I feel like it must be said. We can do all these things to try to get individuals into the healthcare workforce. But with regards to our Medicaid program, if we don't fund the Medicaid program appropriately, then workers, even if we have them trained to do it, won't be able to work in those sectors that rely on Medicaid because the program doesn't fund it and the wages aren't there. So as you're considering all of these workforce issues, I ask that you also consider the Medicaid budget and how those two are linked together and work to make sure that we do have an adequately funded Medicaid budget so that we can have the workers trained appropriately and then want to be able to work in these sectors. So with that, thank you very much.
Thank you, Ms. Kaufman. Next is Erin Dorian again from the Maryland Hospital Association. Ms. Dorian.
Thank you, Madam Vice Chair, members of the committee. For the record, Erin Dorian, Vice President of Policy here at the Maryland Hospital Association. I want to thank Senator Beidel for introducing this really important bill. You know, you've heard a lot about the current healthcare workforce crisis. As Dana said, the COVID-19 pandemic just exacerbated that crisis. Any long-term solutions will require a multi-stakeholder approach, which is envisioned in this commission. This commission will look at the root causes of our workforce crisis and develop both short-term and long-term policy solutions that I hope to see in future legislation in front of this committee, as well as the budget committees and the health committees on either body. The hospital field fully supports this effort. We're ready to engage as this bill moves forward through the legislative process and participate in the commission in any capacity that we can. We urge a favorable report on SB 440. Thank you very much for your time.
Thank you, Ms. Dorian. So subsequent witnesses, we know there's a crisis and we know that Senator Beidel, that you're here for Senator Beidel's bill. That's why you signed up as favorable. So, but if you have data or any expertise within your lanes, that would be especially helpful. Next witness is Aaron Greenfield, Leading Age Maryland. Mr. Greenfield, welcome.
Thank you, Madam Vice Chair, Mr. Chairman. Aaron Greenfield on behalf of Leading Age Maryland, a community of more than 135 not-for-profit aging services organizations serving residents and clients through an array of facilities and affordable senior housing. There's not much more for me to add, Madam Vice Chair, than that Aaron, Dana, and Senator Beidel have already stated, other than to, again, reemphasize the point to engage the industry as much as possible, where the industry is closest to this challenge, and in order to find a sustainable solution, recognizing that this won't be a panacea, but having us involved is really critical. And for those reasons, we request a favorable report. Thank you, Madam Vice Chair.
Thank you, Mr. Greenfield. Next up, Robin Elliott, Maryland Nurses Association. Welcome, Ms. Elliott.
Robin is actually stuck in HGO right now.
Scott Tiffin is here pinch hitting. You do not look like Robin Elliott.
Sorry about that.
Yeah, normally we don't really do substitutes, but we do understand that people are in other committees. So Mr. Tiffin, you may begin.
Cool, thank you so much. I'm here on behalf of the social workers, the school psychologists, the Maryland Nursing Association. Not super much more to add. There's some amendments in our written testimony. Primarily, we just wanted to highlight that we'd like some consideration of healthcare provider shortages in schools. It's been an ongoing issue, and so we just kind of want to make sure the commission looked at that as well. And then we wanted to have some stakeholder input on some advisory committees. But that's all I'll add, because I know you guys have a busy time.
Thank you, Mr. Tiffin. I'm just gonna ask a quick question, Mr. Tiffin. When you talk about healthcare providers in schools, would you be talking about physical, mental, or both?
Both. So the school nurses and then the behavioral health providers in particular, we have big shortages.
Thank you. Appreciate that clarification. I see no questions for Senator Beidel or any of the witnesses. We have one unfavorable bit of testimony from Mr. McAvoy, who is back with us today. Vince McAvoy, are you with us? I do not see Mr. McAvoy. And Robin Elliott.
He's not here.
Okay, and Robin Elliott just entered the room from the House hearing, but Mr. Tiffin took care of your testimony, Robin, so thank you. So seeing no questions, no other witnesses, that completes the hearing on Senate Bill 440. Thank you, Senator Beidel. Take care. We'll see you in Finance. All right, colleagues, the next bill is Senator Eckert. Senate Bill 154, Advanced Practice Registered Nurse Compact. Senator Eckert, I see your pink. Welcome back to EHE. Good to have you here. You may begin your testimony.
Thank you very much, Vice Chair Kagan. For the record, Senator Addie Eckert from District 37 down on the Eastern Shore, and I'm here today to introduce to you this very important bill. Currently, nurses have an opportunity to participate in a compact. That was something that was established through the Board of Nursing a number of years ago. But unfortunately, our advanced practice nurses, that would be nurse practitioners, clinical nurse specialists, nurse midwives, et cetera, are not able to participate in that compact. To participate in a compact means that you're able to have licensure in one state, like Maryland, and then you would be able to practice across state lines in any of the other compact state. This was highlighted because of the pandemic, because of the severe shortage and the ability of working through telemedicine and telehealth. So this is an opportunity that we have as a result of all of the challenges we had through the pandemic to go ahead and join a few other states to get that compact established. I did want to say that to establish the compact through the Board of Nursing does not automatically entitle any of the advanced practice nurses to participate, because each group and each individual would then have to apply for that to have that additional privilege as they work on implementing that. So I would urge your favorable consideration of this very important new change in structure that we can grow into and follow clients across state lines. I have a couple of individuals with me today who are on a panel. If I might just introduce who they are, and then they can pick up the ball and add some more information. We
do have the list. I don't know if our list matches yours, Senator Eckert.
I have Karen Evans from the Board of Nursing, Nicole Lavanas from the National Council of State Boards of Nursing, and Shirley DeVeras.
We do have those, and we
All
have
right.
as well. So thank you, Senator Eckert.
Thank
and
you.
Karen Evans, you may begin. And as the lead witness, you have up to 5 minutes, but don't feel obligated to take the whole thing.
Thank you. Thank you so much, Madam Vice Chair. Okay, it's nice to see you again. And thank you, members of the committee. For the record, my name is Karen Evans. I am the Executive Director for the Maryland Board of Nursing. This is an important bill for several reasons. Senator Eckhart mentioned most of them. I also wanted to state that it also allows military spouses that are APRNs to continue to work upon relocation to another state without interruption at all. Also, this removes the burdensome expenses that an APRN has to face by limiting the number of single state licensors. So they would have to pay for each single state, and this will remove that cost for them. Telehealth is very critical, especially if they have patients in another state. It's important for this bill to proceed. There is, however, 2 conflicts in our current law with the state law for both the certified registered nurse anesthetist, which I call CRNAs, and also the clinical nurse specialists, which are CNSs. Both of them will need to be able to prescribe medication for controlled and non-controlled prescription drugs. The board is aware of the 2 bills that are being introduced this session to authorize CRNAs and CNSs to prescribe certain prescription medications. However, neither bill authorizes full prescription authority for non-controlled prescription drugs, which would be necessary to adopt the APRN compact. So what we are recommending is that if there could be 2 companion bills introduced to cover those particular issues. The last item as well would be that for the CRNAs, currently they collaborate with anesthesiologists and licensed physicians and dentists. If we could have them permitted to assume responsibility and accountability for patient care that's independent of the current collaborative relationship, which is needed in order to adopt the APRN. And the board feels if we can rectify this with those 2 companion bills, that we can be successful. So we're hoping for a favorable request for this bill. And thank you so much, Madam Vice Chair. Thank you so much, Senator Eckhart. Appreciate everyone.
Thank you so much, Ms. Evans. Appreciate your being here. The next witness, as Senator Eckert said, is Nicole Lavanos from the National Council of State Boards of Nursing. Ms. Lavanos, welcome to EHE. You have up to 2.5 minutes.
Thank you, Chair Pinksy, Vice Chair Kagan. Thank you for the opportunity to present here today on Senate Bill 154. I'm Nicole Lavanos with the National Council of State Boards of Nursing. NCSBN is a membership organization dedicated to regulatory excellence for nursing, and we're grateful to be here today on this important legislation to adopt the APRN Compact. It should bring great comfort that the APRN Compact is modeled after the Nurse Licensure Compact, a compact that Maryland pioneered membership in over 20 years ago. Further, like the NLC, the APRN Compact was also drafted by nursing regulators, ensuring that APRN licensure mobility would be safe and protect patients across the country who may access APRN care in person, telephonically, or electronically across state lines. The APRN Compact facilitates licensure mobility for all 4 APRN roles, while allowing each state to maintain regulatory control over licensure and discipline of those APRNs. In order to obtain a multi-state license, the APRN Compact codified licensure qualifications from the national model for APRN regulation. That includes graduation from an accredited graduate level program, obtaining and maintaining national certification, all while meeting their home state requirements too for licensure and renewal. Identical to the NLC as well, the APRN Compact Commission is a governing body made up of 1 voting member from each party state. That commission governs the administration of the compact only, makes no determinations as to the scope of practice of these multi-state licensees, nor does it alter any of the licensure requirements outlined in the bill necessary for obtaining a multi-state license. The commissioner from each state is the head of the state licensing board or their designee, as their expertise as regulators of the profession is sought, just as it is for the Nurse Licensure Compact. Under the compact, practice location remains where the patient is located, and multi-state licensees have to follow the state statutes where the patient's located, as well as the compact's provisions outlined in Article 3. For prescriptive authority, the APRNs will need to follow all controlled substance laws where the patient is located. This is due to the state and DEA's authority over controlled substance prescribing. Over 30 organizations representing nurses, patients, military families, hospitals, and facilities, and innovative business support the APRN Compact. Promoting greater access to quality care, reducing regulatory barriers, supporting military families, and facilitating APRN practice are all important components. And thank you so much for your time.
Thank you very much, Ms. Lavanos. And the senator's third witness is Shelley Tavares, the amazing Shelley Tavares. Before you start your testimony, you have to tell us how many years you've been with working on nursing issues.
19. I first started with, am I unmuted?
You're unmuted. 19? I would have said.
Yes, I started in the House with a committee there. And then I moved to the Board of Nursing where I was Director of Legislative Affairs until I retired in 2019. Okay. So I'm familiar with all these compacts.
All right, so we have to start your time, but we're glad to have you here. Thank you.
Thank you so much. I appreciate it. We as nurses started down the path to compacts. Maryland was the first state to adopt a professional licensing and a health occupation licensing compact. That was in 1999. It was sort of a landing on the moon kind of event for us because it was very exciting. Since then, 39 states have joined the regular compact for nurses, and 6 other states now have pending legislation. And as Delegate Eckert pointed out, and Nicole, it does not cover APRN practice. So we've had, we've all been faced with the COVID pandemic, and it's created enormous challenges for interstate practice. Nearly all states and the federal government approved unprecedented flexibility in licensing rules to allow more interstate mobility for all healthcare professionals. It was enormous help in trying to manage the burden on our healthcare systems during the pandemic. Telehealth became essential for delivery of care, and it's here to stay, and it's probably a good thing because we're getting access to care broadened through telehealth. Most of these temporary waivers, though, for practice are expiring or have already expired. And that's why we need the compact to pick up the slack so that our nurses will be able to go to other states or use telehealth across state boundaries. In September 2021, CMS recognized non-physician compacts, and particularly the NLC and the Psych Pact, where you only have to have one license to work in all the other states. That means that they can use the compact to check whether somebody's eligible to charge, or they can also go to this directly to the state board to see if they are licensed and certified. States and professionals have increasingly turned to interstate licensure compacts, and over 40 jurisdictions now have some kind of compact in place for health occupations. We know that there is some objection, and that's the objection to the 2,080 hours required. And it's understandable. We work really hard for independent practice for our APRNs in this state, and no one wants to see a barrier to practice, but it's only experience that they're asking for. It's not supervised, and it does not keep anybody from getting a license in another state as an APRN.
Ms. Tavares, I'm sorry, your time has expired.
Thank you so much, and I'm asking for favorable on this bill.
Thank you so much. Appreciate it. Next witness is Susan DeLeon Botkin from Family Care of Easton. Ms. DeLeon Botkin.
Thank you very much, Vice Chair Kagan, Chairman Pinsky, and the EHA Committee. I feel I'm in exceptionally good company. I look at my friends who I've been working with for nursing for the last 25 years, and I didn't think we'd still be here doing this. I am Susan DeLeon Botkin. I'm a nationally certified nurse practitioner from Easton, Maryland. I have been practicing in Maryland for 25 years and owned Family Care of Easton, a nurse practitioner practice, for 20 years on the beautiful Eastern Shore. In my spare time, I am president of the Talbot County Board of Education, and I'm very empathetic to the situation in the schools as well. In my practice of approximately 2,000 patients, I draw from 5 Maryland counties, the state of Delaware, and recently from DC. Some of my staff live in Delaware, and my Psych NP is in Baltimore. As you know, Senator Bidel pointed this out, we have lost 500,000 nurses in just this year due to the pandemic, the stresses, and mental fatigue that we are having. We have a problem nationally, and we particularly have a problem in this state because of how close we all work together. This bill provides a tiny bit of relief. The Senator, Shirley Tavares, Ms. Evans, and Ms. Lavanos have already covered the other parts I was going to say, so I'm just going to conclude that during the pandemic, while seeing most patients by telehealth, it became apparent that as healthcare providers, we have to have compact licensure in order to move forward, especially in our area where we are seeing patients, Virginia, Maryland, Delaware, the District of Columbia. Many folks had to be turned away, and with 2,000 patients plus 200 on our waiting list, I can tell you this is tragic for us. This caused delays in getting needed care. It was a burden on patients trying to find a provider. And at other times of provider shortages, this stress is just going to break the system unless we all continue to work together. And I also saw very much that we need to support Senate Bill 440 and 386 just previous to us for the physicians. So I ask you for a favorable report on Senate Bill 154. And ladies, I thank you again for working together.
Thank you very much, Ms. DeLeon Botkin, and thank you for your leadership on the Board of Education in Talbot County. So that is an especially important and challenging role now. So we are grateful for you taking time to join us today. The next witness is Christopher Arnold, whom we've seen many times before from the United States Department of Defense, the State Liaison Office. Mr. Arnold, you have up to 2.5 minutes. Welcome back.
Good afternoon, Madam Vice Chair, EHE. The Department of Defense is grateful for the opportunity to support the policy changes proposed in Senate Bill 154. Military spouse employment profoundly impacts military readiness and our nation's ability to recruit and retain our all-volunteer workforce. My name is Christopher Arnold. I am the Northeast Region Liaison for the Office of the Secretary of Defense. And as you know, the fiscal year 2020 National Defense Authorization Act requires the secretaries of the military departments to consider the quality of healthcare as well as the availability of military spouse license reciprocity when evaluating future basing or mission alternatives. The APRN compact allows an advanced practice registered nurse to hold one multi-state license with a privilege to practice in other compact states. This is significant for the military community in that, along with active duty military spouses receiving the benefit of compacts, active duty members, members of the reserve component spouses, transitioning service members, and other veterans benefit from the mobility provided through the compact. The Department of Defense pivoted in its approach toward licensure after 2017 to consider occupational license compacts as another alternative to improve portability for military spouses. Compacts establish common understanding of competency and its measurement within the occupation, and then seeks to have states approve the compact through legislation. As one of the first states to consider entering the APRN compact, Maryland is poised to play a founding role in developing the compact. In addition to supporting the drafting of model compact laws for professions, Section 1784 of Title 10 United States Code authorizes the Department of Defense to support professions with developing database systems to make these compacts more efficient and operational. And these database systems allow states to share information about practitioners using compact provisions to work in the member states. In closing, we are grateful for the tremendous efforts that Maryland has historically made to support our uniformed service members and their families. We appreciate the opportunity to support the policies reflected in this bill and are grateful to Senator Eckert for introducing this important legislation. As always, as liaison to the Northeast, I stand ready to answer whatever questions you may have.
Thank you, Mr. Arnold. I see no questions of the proponents, so we're going to shift to the opponents. And leading that group is going to be Nayla Russell from NPAM. And as part of your 2.5 minutes, you're going to explain what that group is and what they do. Welcome, Ms. Russell.
Thank you, Senator Kagan. My name is Dr. Nyla Russell, and I represent the Nurse Practitioner Association of Maryland. So I am a resident of Charles County, as well as a nurse practitioner in St. Mary's County. And as I said, I'm here in my capacity as president-elect for the Nurse Practitioner Association of Maryland, and we would like to testify in opposition of Senate Bill 154. So NPM is the only professional organization that solely represents nurse practitioners in Maryland, with over 800 nurse practitioner members, and our organization does not support adopting the APRN compact. As a nurse practitioner and faculty, I have followed the APRN compact over its many iterations, and like many nurse practitioners, I've been supportive of the concept of a compact that would reduce barriers to practice. And I acknowledge the barriers that exist and have been compounded by COVID. However, this new version of the compact is problematic and has the potential to enhance barriers. This includes a 20-80-hour transition to practice, which my colleague Dr. Claire Bodie will be addressing, as well as issues of administrative oversight. There's no APRN advisory committee in this APRN compact. Any administrative oversight must include an APRN advisory committee so that the necessary lens can be part of that oversight to provide consultation and direction and oversight. Further, compact administrators consist of the heads of boards of nursing or a designee, and there's no guarantee that advanced practice nurses will be sitting on this governance board. Currently, the Maryland Board of Nursing Executive Director is a nurse, but not an APRN with knowledge of advanced practice. Unfortunately, any legislation that is passed cannot be readily amended, as the compact requires adoption in full in order for a state to participate. Therefore, these issues must be addressed cohesively within the nursing profession in order to satisfy this requirement. Adoption of this iteration of the APRN compact is contentious within the nursing profession, with more than 40 national nursing organizations opposing the APRN compact in its current format, along with several organizations within Maryland. So the issue is we as a profession, we need to work out the details. The devil is in the details. Nurse practitioners are the largest Maryland stakeholder in this compact, accounting for 84% of the APRN workforce in Maryland. NPM affirms that we need to increase access to patient care in Maryland, and we welcome partnerships to enact meaningful legislation that will impact the health of Marylanders today. The APRN compact will not impact Maryland patients until an additional 4 states pass legislation. Adopting the APRN compact as it is currently written is premature. In order to be eligible to join the APRN compact, states must pass the model legislation without any material differences.
Ms. Russell, thank you very much for your testimony. Your time has expired. Marcella Leith is next on favorable testimony. Is Ms. Leith here?
Yes.
Hello, welcome. You have up to 2.5 minutes.
Hello. Thank you, Vice Chair Kagan, Chairman Pinsky, and members of the committee. My name is Marcella Leith, and I am a doctoral student in the Adult Gerontology Acute Care Nurse Practitioner Clinical Nurse Specialist Program at the University of Maryland School of Nursing. I graduate this May, and after I pass the board exams, I will begin to practice as an advanced practice registered nurse, or APRN. While I am in support of the APRN compact concept, I'm opposed to this bill as it is introduced. One of the first things we learn as APRN students is the consensus model for APRN regulation. This model is called LACE and stands for Licensure, Accreditation, Certification, and Education. LACE is drilled into us from day one. As APRNs, we're required to know how our practice is regulated so that we can provide safe, quality patient care. LACE is important for the full practice authority and was developed out of the Institute of Medicine's Future of Nursing call to have all nurses practice to the full extent of their education and licensure. APRNs are qualified to practice once they graduate from an accredited program and pass their national certification exam. I am opposed to and afraid of this bill because the stipulation of 2,080 hours in this bill sets a dangerous precedent that can be used to restrict full APRN practice authority in the future. The hour requirement might not feel like a big deal to some, but for me, someone who has spent the past 5 years in a doctoral program with the expectation that upon graduation, I will receive full practice authority and will have met all the necessary requirements for licensure, including over 1,000 clinical practice hours. To be told that I am now required to practice for 2,080 more hours before I am eligible to enter a CPRN compact for no reason based in evidence and against the LACE model makes no sense. If this bill passes, Maryland will be moving in the wrong direction against APRN full practice authority and opening APRNs to potentially harmful restrictions in the future. Our goal as APRNs is to provide safe, quality, evidence-based patient care. This bill directly contradicts that goal. Thank you to the committee and everyone for listening to my testimony today.
Thank you, Ms. Leith. And our final witness on this bill is Claire Bodie, who has signed up as an individual. Sandy Spring, Maryland. Ms. Bodie, welcome.
Thank you. Vice Chair Kagan and committee members, thank you for your time today. My name is Claire Bodie. I'm an assistant professor at the University of Maryland School of Nursing, teaching in the Family Nurse Practitioner program. I also work as a nurse practitioner 1 day a week in a primary care practice. While I support the concept of the APRN compact license, the current legislation has significant concerns for graduating nurse practitioners. A student who graduates from an accredited program and passes the national certification, as you know, is qualified to practice to the full scope and licensure. The inclusion of 2,080 hours as a prerequisite for compact licensure is not supported by the evidence and is in direct conflict, as was stated earlier. The 2,080 hours presents a barrier to full practice authority. The American Nurses Credentialing Consensus Model supports the advanced practice RN compact, but requires advanced practice nurses practice with no regulations that require collaboration, direction, or supervision. The advanced practice roles are complex and varied. Therefore, advanced practice registered nurses, the compact must include representation on the board and an advanced practice advisory committee that includes representation from all 4 advanced practice registered nurse roles and representation from accreditation, education, certification, and practice. The current legislation presented here from the National Council of Board of Nursing is in opposition to both areas of this consensus model. Joining the advanced practice RN compact must move the advanced practice RN roles forward. There is no rush to get this through this year. It will have no impact on current advanced practice RN practicing. It cannot go into effect until at least 7 states have agreed to the compact. This legislation cannot be amended once it is enacted by any state legislatures. Considering the legitimate concerns with this legislation, there is no need to rush into the compact at this time. Instead, we, the advanced practice registered nurses, need to work with the National Council of Boards of Nursing to develop an advanced practice RN compact that is in alignment with the consensus model and the Maryland Advanced Practice Registered Nurses. Thank you for your time.
Thank you very much, Ms. Bodie, for your testimony. I see no hands up from colleagues, but I actually had one quick question myself, and I think I'm inclined to send it to Ms. Russell or Ms. Bodie. I'm not sure. I'm in the bill on page 8, and I don't know if you have it in front of you, but line 26, colleagues, page 8. And this is a big, long bill, 29 pages for anyone watching at home. I cannot say that I've read every word on every page and analyzed it, but I am curious about the need in this compact that everyone have a valid United States Social Security number. If you can take a hack as to why you think that is and the wisdom of that, and then maybe regardless of your answer, maybe if Senator Eckert or one of the proponents might be able to speak to that briefly with an alternative perspective. I would love to understand that better. And I've been talking to legal counsel about this. I just want to understand the wisdom. So Ms. Russell, do you know the answer, or Ms. Bodie? And if not, we can toss it to proponents.
Sorry, I do not know.
Okay.
I do not know.
Okay. Senator Eckert, do you or any of your proponents? If not, we can ask counsel to look into this more.
Oh, yeah, I can just speak.
Ms. Evans? It looks like Ms. Evans knows. I'm sorry.
Go.
Yeah.
Whichever.
Yeah, well, I can start with that and then I'll pass it over. But in order to participate with the compact, there are actually like common consensus items collected from all of the states, be able to work together. So it's the 2080 hours, it's the Social Security number, it's a number of aspects are what has been agreed on by a number of states to be able to provide the best opportunity for folks to join on board. We're never going to satisfy any one group. And so in order to get people to buy in, you have to have some kind of a consensus framework. And then I'll pass it off to Karen Evans.
Ms. Evans, really briefly, please.
Yes, Madam Chair. Yes, in even in our current RN and LPN compact, you have to have a Social Security number. So there's 11 requirements there, as well as part of the family law here in the state of Maryland. Sorry, I can't quote you the exact list, but it's also that as well.
Thank you. I appreciate it. So there's just a lot of conversations around nursing shortages, and I just wonder if there's anything that's not mandatory that can ensure that Marylanders get great health care. I'm wondering about that. So thank you both. I see no other questions. So that completes the hearing on Senate Bill 154. Thank you, Senator Eckert. We will see you soon. In Budget and Tax, the next bill, Senator Lamb, are you here? Are you good with going, or do you want to go a little later?
I can go.
Okay, Senator Lamb, Senate Bill 305, State Board of Physicians to spend.
Madam Chair?
Yes.
Hello. Senator Eckert has another bill.
Yeah, I think she has another bill. That's what I was confused.
She sure does. I apologize.
Thank you.
Yes, I apologize. 513.
Thank you, Mr. Chairman.
Clinical nurse specialist prescribing authority. I'm sorry, Senator. That is, that's my fault. Please begin.
Thank you very much, Madam Co-Chair and Mr. Chair and members of the committee. I'm here today, Senator Eckert, on Senate Bill 513, Health Occupations Clinical Nurse Specialist Prescribing Authority. This is really curious because this bill is actually part of what is needed to begin to build that compact consensus and move forward. But this would essentially expand the scope of practice for the clinical nurse specialist to include prescriptive authority and the ability to order durable medical equipment. And that will be arranged through the Board of Pharmacy, and they will be able then to reorder meds or renew meds or go ahead and have limited prescriptive ability as stated. Interestingly enough, in 96 when we first came into the Maryland General Assembly and the House delegates. This bill had been introduced that long ago, was met with resistance. And as you heard from the other advanced practice nurses, we've come a little bit of a long way since then. So I think it's time that we take this next step in advanced practice. I also have a couple of witnesses with me today that should be on your list. Sharon Allen, president of the Maryland chapter of the National Association of Clinical Nurse Specialists. Miranda Jackson Parkin, who is an assistant professor at the University of Maryland School of Nursing, and Marianne Hiles, who is a clinical nurse specialist, Frederick Health Family Center. And full disclosure, I am one of those CNSs as well.
Thank you, Senator Eckert. Appreciate your testimony. And as you said, Sharon Allen, CVAN ACNS is your lead witness. Ms. Allen, you have up to 5 minutes, and you don't need to take all your time if you don't need them. Welcome to EHE.
Thank you, Senator Eckert, for your generous sponsorship, and thank you, Madam Vice Chair Kagan and Chair Pinsky and the committee members for allowing me to give my support in testimony. My name is Dr. Sharon Allen. I'm a certified and registered clinical nurse specialist and president of the Chesapeake Bay affiliate, which is the Maryland chapter of the National Association of Clinical Nurse Specialists. The clinical nurse specialist is just one of the 4 advanced practice nursing roles prepared at the master's or doctoral level, and they are educated and trained to diagnose, treat disease and illness, and prescribe. Currently, 80% of the states and the U.S. Department of Veterans Affairs have granted CNSs prescribing privileges, and Maryland has not. CNSs are change agents. They work across the continuum of healthcare to improve patient outcomes, and they're on the front line of all work done to get evidence-based standards of care. The CNS is not a duplicate role to the other advanced practice roles, but able to fill gaps to make improvements in the efficiency and the effectiveness of healthcare delivery. Prescribing is a very complex process, and it involves much more than ordering medications. Prescribing authority would allow the CNS to follow through on their patient-specific treatment plans, order patient referrals, lab work, home care, diagnostic tests, titrate medications, order specialty equipment like pressure relieving beds, a walker, oxygen, wound care supplies. And this is all just to promote the quality management of even the most vulnerable and complex patients. Not having prescribing authority is crippling to the continuity of quality care. My personal experience managing post-op cardiac surgery patients after discharge is a prime example how a CNS can fill the gap. It can take 6 to 8 weeks for a patient to have a follow-up appointment with their primary care or their cardiologist. And I fill this gap managing these patients until a safe transition to their community healthcare team. I identify, diagnose changes in their medical status, adjust their medications, monitor their symptoms, keeping them safe and preventing readmissions to the hospital. Current Maryland law preventing me from having prescribing authority means that I need to interrupt the workflow of another provider, taking them away from what they do best simply to sign my orders. Current Maryland law is very binding, and the CNS does not live in a silo. We're collaborative team members working on strong patient advocates and doing what we do best. We're respected by the other healthcare providers, and it's all done to provide the best and safest care to our patients. I stand in strong support of this bill, and I'm asking you to vote favorably for Senate Bill 513. I thank you very much for taking time to listen. And our next speaker is Miranda Jackson Parkin.
Thank you, Dr. Allen. Miranda Jackson Parkin, yes, you are. I see you in the room. Welcome to EHE. You have up to 2.5 minutes.
Okay, thank you. First, I would like to thank Senator Eckert, Chairman Pinsky, Vice Chair Kagan, and the committee members. In the state of Maryland, we are very fortunate to have 3 clinical nurse specialist programs: University of Maryland, Johns Hopkins, and the Uniformed Services University of Health Sciences. As one of the 4 advanced practice nursing roles, the clinical nurse specialist, or CNS, completes the same foundational educational requirements for advanced practice nursing. Advanced pharmacology, advanced physiology, and pathophysiology, advanced physical assessment are those 3 core courses for all APRNs. In addition to our prior professional practice as a registered nurse, the CNS completes coursework specific for practice and patient population. This often takes 3 to 5 years. Doctoral level programs require a minimum of 1,000 clinical hours of practice for graduation. A national board examination must be passed to gain certification for clinical practice. And to maintain the certification for clinical practice, the CNS must complete 150 clinical education units, of which 25 must be in pharmacology, with the minimum practice of 1,000 clinical hours every 5 years. The CNS possesses the education, knowledge, clinical reasoning, and decision-making. However, in Maryland, they are unable to prescribe. The cornerstone of CNS practice is collaboration and utilization of evidence-based practices. Today's healthcare environment requires this multidisciplinary or team-based approach to care. The National Academies of Medicine support this as a best practice to achieve safe and effective quality patient outcomes. The unique knowledge and skill each discipline brings to the healthcare environment is respected and utilized to meet the needs of the patient or the individual. The discipline of nursing offers a holistic approach, and to discount this holistic, unique value, knowledge, and strength of nursing by comparing it to other disciplines is to diminish the value of them all. COVID-19 has taught us the power and value of a multidisciplinary approach. Granting prescriptive authority will optimize CNS practice. In conclusion, as a duly certified CNS NP and assistant professor teaching in a CNS program, I am aware of the current practice limitations. Granting authority to optimize and retain CNSs in Maryland is better than possibly losing them to Delaware, West Virginia, or the District of Columbia. These states have granted prescriptive authority to CNSs. Support the CNS role in Maryland and their practice by a favor report for SB 0513. Thank you for your time.
Thank you, Ms. Jackson Park. And Mr. Chairman, I see that your hand is up, and so is Senator Lamb's. There are a couple more witnesses. Do you want to ask your question, or can you hold?
I'll wait.
Okay, thank you. Senator Lamb, you okay? All right. The next witness is Mary Ann Hiles. Ms. Hiles, I see you here, and you have up to 2.5 minutes.
Thank you. Good afternoon, and thank you, Senator Eckert, Chairman Pinsky, Vice Chair Kagan, and members of the committee. My name is Mary Ann Hiles, and I am a perinatal clinical nurse specialist. I've been a registered nurse for 29 years and a clinical nurse specialist since 2011. I've spent the majority of my 29 years in nursing caring for pregnant and postpartum women and their newborns. My graduate and postgraduate work as a CNS has been in the care of this patient population, with a particular interest in pregnant and postpartum patients impacted by opioid use disorder and their newborns experiencing neonatal abstinence syndrome. Pregnancy is a critical time in a woman's life. Pregnant women do not wake up and decide they are going to use drugs. Women with opioid use disorder become pregnant. They have a chronic relapsing disease that impacts not only the woman, but her newborn. Women with opioid use disorder know this and are motivated to change during pregnancy, but we need more providers to help them. While providers in Maryland who can prescribe buprenorphine are increasing, most providers are not educated in the unique needs of pregnant patients and the impact of neonatal abstinence syndrome on the newborn. Our wonderful OB providers are experts in the care of pregnant women, but often not in the treatment of opioid use disorder. As a CNS, I am often the one to advise our OB providers on the proper care and medications to support our pregnant and postpartum patients with opioid use disorder while in the hospital. It has been my job to develop policies, order sets, procedures for these patients when they come into the birthing unit and through their postpartum stay. It is evident there is a gap in care in both the hospital and community for pregnant patients with opioid use disorder. Federally, the Support Act of 2018 granted CNSs the ability to prescribe buprenorphine to patients, but in the state of Maryland, I cannot without prescriptive authority. One of the main reasons I became a CNS was to improve outcomes for women and newborns impacted by this chronic relapsing disease. Integrated opioid use treatment into provider practices is much needed in our communities, but there is still a gap in this care for pregnant women. Having prescriptive authority would fill this gap by allowing me and other CNSs to prescribe buprenorphine therapy to pregnant women and support our OB providers in the care of this high-risk population. Thank you so much for your time, and I ask you to please vote favorably for Senate Bill 513.
Thank you very much, Ms. Hiles. And our final advocate here is Lorraine Diana. Ms. Diana, welcome to EHE.
Thank you and good afternoon. Chairman Pinsky, Vice Chair Kagan, and committee. I thank you for the opportunity to present my testimony here today. I'm Lorraine Diana. I'm a family nurse practitioner and I've been practicing in Maryland for over 41 years. During most of that time as an NP, I've had prescriptive authority. In that same time frame, CNSs have not. 40 states and the Veterans Healthcare System have granted prescriptive authority to CNSs, and it's time to close the gap in Maryland. So right now we have 3 healthcare crises going on. COVID is at the forefront, and with that, of course, the nursing shortage, which is so critical. But there's also this opioid crisis, and it gets a lot of attention, but not nearly enough, because we just don't have enough mental health providers or people who can prescribe buprenorphine in the state. So right now we have 310 clinical nurse specialists. 40% of them work in hospital-based acute care and outpatient settings like Marianne and Sharon. The other 60% or 188 of our clinical nurse specialists are psych mental health providers. And as Marianne said, under the Federal Support Act, they were authorized to prescribe medications to treat opioid use disorder, but in Maryland cannot. And since 1991, under COMAR, psych mental health CNSs can manage therapies, including medications for their patients, but cannot prescribe them. It causes a gap for patients in care with opioid use disorder and disproportionately affects those patients that are in inner cities and rural Maryland.
I realize, hold on.
Yeah.
You're good. Sorry, please.
Oh, I'm sorry. And only 2 Maryland counties are not partial or full mental health provider shortage areas in Maryland. So adding this ability for CNSs would allow 310 more providers to address the opioid crisis. Scope of practice bills like this have become a tug of war between competing professional interests and often result in curtailing access to healthcare for our citizens. I thank you for listening to me, and I ask for a favorable report on SB 513. And thank you, Senator Eckert, for sponsoring this bill.
Thank you, Ms. Diana. So there is a bunch of written testimony, both favorable, a bunch of favorable, and as well as a bunch of unfavorable, but colleagues, you can find that in your packets. Mr. Chairman, you have a question.
Yeah, a comment and a question. One, to follow up on what you just mentioned, Madam Chair, Vice Chair. There's extensive written testimony from both sides. So I strongly encourage the committee to review that. Secondly, I believe I'm going to have committee counsel create a chart. All of these categories, CNS and RN and LPN and nurse anesthetist, what their authority and rights to do, whether they can prescribe or not, I think would probably be helpful to the committee. So I think I will ask her to create a chart and also the conditions for the compact. These issues are coming up, affecting a number of the categories in the nursing field. And so we'll provide a chart to the committee over the next week or so, and maybe do a briefing to give you some context as well. So no questions, just a statement. Thank you.
Isn't that so, Mr. Chairman? Senator Lamb?
Yeah, thank you. So this may be a question to the subject matter experts here, right? So there must be some distinction between a certified nurse specialist and a nurse practitioner, an NP, right? So can someone explain that in layperson's terms? Because most of the committee is not a healthcare provider. What is the distinction in layperson's terms that they can do differently, and how is their training different?
Probably Miranda Jackson Parkin. would probably be the best person since she is a professor. Is she on?
I'm here. The question that you asked is to differentiate between the two practices?
Is there a difference between like a CNS and an NP?
Basically, they do have the same foundational education coming through the program. The nurse practitioner is usually tends to be more based within, I'd say more of kind of this more medical model. The clinical nurse specialist is based within more of a stronger nursing model. They treat across the spectrum in terms of age. The clinical nurse specialist works within what they call spheres of impact. So you have those who work within an area of specialty, and that may be directly with patients and families such as Marianne and Sharon. It could be working within systems. You see a lot of clinical nurse specialists who are more in working with this systems and helping hospitals to maintain certifications for accreditation. And then you have clinical nurse specialists who are working specifically in terms of with the nursing population. But the hallmark is that we are all APRNs and that we practice together. The clinical nurse specialist role does have lots of variations, but one of the chief is that they have an area of specialty in which they worked and excel themselves to become an expert within those areas. So you see some variation.
Is a CNS less clinical than an NP? Because I'm not sure that I can even tease apart the differences there between what you just described.
I think in Maryland, the CNS role has been limited based upon the fact that they do not have prescribing privileges. In the states in which clinical nurse specialists have prescribing privileges, their practice as a nurse practitioner, you really probably would not notice differences. We do have a slightly different approach because of the model, but you would not notice a difference. In Maryland, the practice is very limited. So to tell you how the role is used in Maryland is very different from what I've seen in other states.
But then if in other states the distinction is no longer there because they have prescribing authority, then why are there different terminologies for, like, why would somebody be labeled as CNS versus an NP? Just based on the training that they went through?
It's gonna have to be based going off some of the format. Our University of Maryland has what we call a blended program where they're able to sit for both boards. The clinical nurse specialist may spend more time looking at some diagnosis and management courses. The nurse practitioner, the clinical nurse specialist, they too can look at those, but they're also looking at courses that have to do with quality of care, evidence-based practice, how to look in systems, working across lines in collaboration. So they do get a little bit broader in terms of what their education is when they're looking at that CNS role. I don't know if that kind of clarifies your question.
I guess, sorry, go ahead.
If I might jump in.
Sure.
Dr. I am a clinical nurse specialist. I am not a nurse practitioner. Nurse practitioner, and there are psychiatric nurse practitioners. They are nurse practitioners first. As a clinical nurse specialist, and the role has evolved since I did my graduate work, but the clinical nurse specialist has 4 areas of expertise: direct care, education and teaching for others, research, and then collaboration, like an entrepreneur working among systems, as Miranda stated. So the focus has been more on those 4 areas of domain than focused on exclusive, like prescriptive and diagnostic. It has evolved out of the need because of access to care. And our educational institutions then have been expanding that role and providing that education and opportunity for clinical experience to meet that need, if that helps at all.
Yeah, that's helpful, I guess. And I guess that's helpful because that at least tries to delineate the differences between maybe their training that they receive as either an NP who's practicing maybe more clinically versus a CNS who doesn't have the full clinical tool set because that's why you're here for this bill. but I guess it sounds like the training is a little bit different in that there's maybe a little bit more components or competencies that touch on things like research or systems-based practice or academic type work that's different than a traditional NP. And I guess maybe some of the opposition testimony that's in the written packet touches on the fact that those differences give CNS graduates a little bit less training in some of these other areas that the opposition thinks is still important to have, that the NPs receive, that the CNS graduates don't. And so, I don't want to dive into this much more because, time and such, but I think it's worthwhile and helpful the way you tease that out so that we can look at this a little more closely.
Thank you. And if I can be any further resource offline, I'll be glad to do that, having been through the evolution of these roles over time.
Thank you, Senator Eckert, and thank you, Senator Lamb, for your thoughtful questions. Seeing no other colleagues with questions, that completes the hearing on Senate Bill 513. And now, Senator Eckert, you may go back to your committee.
Thank you very much. Thank you for your time. And I do have an amendment to that last bill. Take a look at it. Thank you.
Thank you, Senator Eckert. Now we get to Senator Lamb, Senate Bill 305. And that is State Board of Physicians dispensing permits. Senator Lamb.
All right, thank you, Chairperson and members of the committee. Happy to be here to present Senate Bill 305. For the record, Clarence Lamb, Senator in District 12. So under the current process for physicians who wish to obtain a physician dispensing permit, a request for a permit is made to the Board of Physicians, which sets the requirements and standards that the requester must meet. The enforcement of these requirements and standards through initial and routine inspections are then handled by the Office of Controlled Substance Administration, OCSA, the Office of Controlled Substance Administration, and reports and violations that are noted by OCSA are then sent back to the Board of Physicians. Since disciplinary action related to violations during inspections are handled by the board, when reports of violations are incomplete or missing evidence, this creates unnecessary delays when the Board of Physicians inspectors need to return to the offices of the permit holders to conduct additional inspections of these violations. This bill will transfer the inspection requirements of physicians' offices so that the board is responsible for inspecting the dispensing permit holders instead of the Office of Controlled Substance Administration. I think in the past, it was this way where the initial responsibility for these inspections lay with the board. In the past, it was moved to OCSA. This bill would move it back to the board. The bill also will remove physician-related language from certain health occupation section, but move it into existing statutes. So it's not really changing anything there as you read the bill. It's just moving it, the physician-related language from one part of the statute to the other. The board will be responsible for the inspection of physician offices within 6 months after the dispensing permit is issued, and once every 2 years after the dispensing permit is renewed. If there are violations found related to dangerous and controlled substances, the board will notify the Office of Controlled Substance Administration, OCSA. SB 305 will alleviate unnecessary delays in conducting inspections by transferring the responsibility of inspecting permit holders from the Office of Controlled Substance Administration to the Board of Physicians. It will also minimize delays in the investigative process and expedite the board's ability to conduct disciplinary action. This will increase patient protection and be more cost-effective and a quicker process for dispensing permit inspections. I think this bill is important because it will help provide the Board of Physicians the primary responsibility of reviewing these and conducting these inspections. Many of the members of this committee may be familiar with scope battles that happen between the health occupations. I think this is one that's akin to that, but really between OCSA and the Board of Physicians. I think in this instance, the Board of Physicians is justified in taking on this responsibility and in the transfer of this role back to the Board of Physicians. And that's why I'm supporting this bill. You'll hear from members of the Board of Physicians or representative of the Board of Physicians shortly. But I think this is good practice for a number of reasons that will be enumerated. So I'd like to thank the committee for consideration of this bill and urge a favorable report on SB 305.
Thank you, Senator Lamb. You have two witnesses. We will start with your lead witness, Matthew Dudzik, who is still here with us from the Maryland Board of Physicians. You have up to 5 minutes, Mr. Dudzik.
Good afternoon. Thank you, Senator. Thank you. And good afternoon, Madam Chairman, members of the board, or members of the committee, I'm sorry. For the record, once again, Matt Dudzik with the Maryland Board of Physicians. I think that the Senator did a great overview of the process. As you might imagine, if you are a physician and you want to dispense directly from your office, there are various requirements. There are requirements regarding things like labeling, storage, record keeping, and so on. And it's basic safety standards. And the way those requirements and standards are enforced is by having these permit holders receive periodic inspections. As the Senator referenced, right now those inspections are conducted by the Office of Controlled Substance Administration. However, their agency is solely acting as middlemen here. Their inspectors are limited to performing the inspection and sending a report back to our office for processing. They have no ability to act independently on those inspections. And meanwhile, we cannot begin an investigation until we receive those reports. The reports themselves are often incomplete due to outdated information on the permit. And because their inspectors do not collect evidence for the board, in cases where violations are noted, we typically have to re-inspect with our own board inspectors. The board, of course, in order to carry out our duties, we have a number of inspectors currently. That is how we investigate complaints. That is how we pursue disciplinary action with the 45,000 licensees that we currently cover. It is, unfortunately, it's a circuitous process. It ends up being costly, it's time consuming, and worst of all, it fails to adequately protect the public. So the bill is very simple. All requirements for dispensing permits are remaining exactly the same. We are simply removing those requirements to Title 14, which is the Medical Practice Act, and making the board responsible for the inspection piece of this process. It's a simple fix, but it is one that we think can do some real good because, to be quite frank, the current system does not work. There are Maryland patients right now who are seeing doctors and being dispensed medication without adequate oversight. There are numerous cases where an inspector has gone to one of these offices, identified that the office is not properly storing medication, not keeping adequate records, not meeting all of those requirements that are put in place to protect the public. And the doctor will be allowed to keep on dispensing as we wait for the case to be referred back to the board, as we send out board inspectors to re-inspect and collect evidence and then begin that investigative process from scratch. That is real harm that is occurring right now under the current system. So we are simply proposing that rather than having a third party perform this inspection, we will perform the inspection ourselves, collect all necessary evidence, and in cases where violations are found, immediately open an investigation. We think that it is just a very straightforward solution to a problem that has been persistent for the past almost 10 years now, and we urge the committee to submit a favorable report.
Thank you, Mr. Dudzik. Next, we have Dana Kaufman from MedChi.
Thank you. Thank you very much, Chair Kagan, members of the committee. For the record, I'm Dana Kaufman on behalf of MedChi. I believe that Senator Lamb and Matt laid out the purposes of the bill very much. We are in strong support, and we do believe that it'll increase enforcement efforts. I want to focus my testimony, however, on some other statements that have been made about this bill in some opposition testimony and what this bill is not doing. And this bill is not diluting the Office of Controlled Substance Administration as it relates to CDS, Controlled Dangerous Substance. The Office of Controlled Dangerous Substance will still have jurisdiction over those physicians that have dispensing permits that also have a CDS registration. That is already in Title V And through that power, or through that authority, they have the power to regulate those physicians as well as to inspect those offices. And this bill makes no changes to their authority. I also want to say that this bill does not eliminate any training requirements for dispensing physicians. That is very clear. If you look at page 9, they are still under education and training requirements through the COMAR regulations. It does not remove any requirements that dispensing physicians, if they are dispensing CDS, have to the prescription drug monitoring program. That authority and requirements is found in Title 21, Subtitle 2A, and this bill does not make any changes to those. So any physician that has a dispensing permit that also has a CDS registration will be and still remain subject to the Office of Controlled Substances Administration, as well as the prescription drug monitoring program. And I really want to emphasize that point because I think that this bill is being very convoluted in the concern being raised. And again, we think it will increase enforcement activity. And what was stated right at the end is that if there is any issues or violations found by the Board of Physicians, they must report that to OCSA. So it is a double check. So with that, we do urge a favorable report. Thank you.
Ms. Kaufman, I might have missed OCSA. Can you just tell us what that is, please?
Oh, hopefully I made that acronym. The Office of Controlled Substance Administration.
Thank you. And that's federal?
No, that's the state. It's within the health department as well.
Thank you. Appreciate that. I wonder, Senators, we have the Attorney General unfavorable. I'm inclined to hear from the Attorney General and then take questions. What's your thinking? Senator Riley, Senator Pinsky? Okay, let's hear from the Attorney General's office so we have their perspective too, and then we'll go. Is Ms. O'Connor here? Yes. Pat O'Connor from the Attorney General's office. Welcome back.
Yeah. Thank you so much. Pat O'Connor for the record from the Office of the Attorney General here in opposition to the bill. The most consequential effect of the bill has not yet been raised, and that is the effect that would happen, the adverse effect on criminal prosecutions should this bill become law. Let me explain. There is an absolute prohibition in 14.410 Health Occupations article against admitting any record or file from the Board of Physicians or any of its investigatory bodies. If the board is vested, as this bill would have, with exclusive investigatory and inspection authority, it wouldn't be exclusive investigatory, it would be an exclusive investigatory authority over the dispensing permits, that would place all evidence, all files and records in the lockbox created by that absolute privilege. Now, in previous discussions, there have been references made to subpart C of 14.410, which appears to create an exception, or does create an exception, for medical records or hospital records that are otherwise admissible. There's another provision that says any other exhibit that is otherwise admissible. We don't know why this body, the legislature, used the word exhibit. Certainly it's different from record. So we would submit that it is not an exception that would allow prosecutors to get this evidence into a criminal trial. Because even if you accept, for the sake of argument, that an exhibit would somehow be admissible, you have to go back to the first part of the statute, which says the only way any of this evidence gets admitted into a criminal prosecution is if all the parties to the board proceeding expressly stipulate to the admissibility of the evidence in the criminal trial. I think it is safe to assume that a physician facing criminal charges will not consent to or stipulate to the admissibility of the board's records. And this is why we oppose the bill. The most effective means of protecting Marylanders in this opioid crisis that has no end has been the criminal prosecution of those physicians who choose to illegally prescribe or dispense opioids.
Thank you, Ms. O'Connor. Sorry. Appreciate your testimony as always. Senator Riley, followed by the chair.
Thank you much, Vice Chairman Kagan. Senator Lamb, I was a little confused by where the responsibility lies, et cetera. So today, the Office of Controlled Substance Administration goes out, does an inspection, finds a problem. They do not currently have the ability to shut the doctor down. Is that right? I'm sorry, shut down the doctor's ability to dispense more controlled substances. Is that right?
I think that's correct. I think the authority lies with
the Board of Physicians.
The Board of Physicians.
Okay, so we have currently the inspection by OCSA refers it to the Board of Physicians, and they have the ability to withdraw the authority for a physician to dispense controlled dangerous substances. Does the physician have a right of appeal? And during that period of appeal, can they continue to dispense controlled substances?
I think they do have a right to appeal. I defer to Mr. Dudzik if they can continue to practice at that time. But I think
the dispensing,
not dispense at that time. That's a good distinction. But I think to the point in my testimony as well, if they find something in OCSA and refer them to the board still has to go back in and inspect again.
Right. I understand that. I got that. Okay. I'm trying to figure out about which one has the authority to withdraw dispensing ability, and if a letter or a document was presented to the doctor, can he continue to dispense during the appeal process?
Thank you for that question, Senator Riley. So there are a few parts to your question, and I'll take them separately. The first is in regard to an appeal process, yes, there are numerous opportunities for physicians to participate in the disciplinary proceedings. There is an appeal process. All decisions can be appealed through the Office of Administrative Hearings.
Sure.
Regarding the ability to revoke dispensing. In extreme cases, the board has the ability to perform, to summarily suspend privileges, or in the case of, for instance, if somebody was dispensing without a permit, to issue a cease and desist. In extreme cases where the safety of the public requires a more immediate response. But in the normal course of an investigation, yes, the physicians certainly have a right to appeal.
Yeah, and so that was my question. My question is, do they have the ability to continue to dispense during the appeal process?
Yes, until there is a final order by the board.
Exactly. Okay. Thank you, Madam Vice Chair.
Absolutely. Thank you, Senator Riley. I'm going to call on the chair, and I'm going to relinquish the chairmanship to the chair because I have a bill in finance, and I will be back shortly. I just want to let folks know that Rockville Police Chief Brito has been watching us and will continue to do so, and is learning about 94 hours of Zooms a day. So thank you, Mr. Chair, your question, and then I hand it off to you. Thank you.
Hopefully what he's observed doesn't lead to an arrest. Thank you. A couple of questions. First, Ms. Kaufman, you said nothing in the bill dilutes the authority of OCSA. And, I'm reading the bill, and, I've been at this a little while. On page 4, it says the Office of Controlled Substance Administration shall enter and inspect the office of the dentist, and it takes out the word physician or podiatrist who holds, and it goes on and on. So by prohibiting or restricting their ability to come into an office, that doesn't dilute their authority? I'm just trying to understand what you stated earlier.
So if you look under section 5-305 of the criminal law article, it does allow, and it specifically states that MDH, which would be through OCSA, may inspect the physician office if that physician office does have a CDS.
Well, then I don't know how those two sections jive.
Well, you have to remember too that not every dispensing physician dispenses CDS. So that's one issue to keep in mind. And
So
then,
you're saying the removal of the language on page 4, line 29 is only saying they can't go into an office of a doctor who's not prescribing restricted medicines.
reverse that and say that the Office of Controlled Substance Administration still can go into a physician's office who has a CDS. So if the concern is regarding opioid prescribing, OCSA still can go into that office. So to your point, for a physician who is not prescribing opioids and therefore does not have a CDS, then the Board of Physicians, yes, would be doing the inspections and not the Office of Controlled Substance Administration.
And let me ask either Mr. Dudzik or Ms. Kaufman if they would respond to the assertion made by the Attorney General's office that based on this language, evidence that is collected by the Board of Physicians couldn't be used in any investigation or criminal case.
Thank you for that question, and I'm happy to answer it. So we, after consulting with counsel, we believe that the exception provided in 14410C is sufficient because it covers any medical or hospital record or other exhibit. This is specifically under a subsection that is titled Other Evidence Not Affected. So the consent requirements under 14410A would not apply to other evidence that would otherwise be admissible. And in fact, on numerous instances where other units of the Office of the Attorney General have proceeded with criminal charges, or the Medicaid fraud unit, they have subpoenaed records, and we have always complied.
So then, if this bill were to even go forward, you would fully support any amendment that explicitly said any evidence acquired could be used in any criminal cases or civil cases.
Yeah, I again, we of course would have to go back to the board, but I don't see any reason why we would have any issue, because currently that is the practice under 14410C.
And let me add, under 14411M, it states that the board, if they determine that any information contained in the record concerns possible criminal activity, that the board shall disclose the information to law enforcement or a prosecutorial official. So there is that piece of the statute too that says it's a shall. It's not discretionary, they have to.
Okay, and my final question, given this shift to putting it more under the Board of Physicians, besides the efficiency, and without trying to throw you a softball, why do you think the Board of Physicians is in a better situation? I mean, some might say it's the chickens protecting the hen house. Why do you think you're in a so much better situation than OCSA to have this oversight?
Okay, thank you for that question, Senator. There are a number of reasons, and a lot of them speak to just general issues with the process. First of all, we are the regulatory agency for physicians. We do not represent physicians. We represent the public. Our core duty is protecting the public through proper enforcement of the Maryland Medical Practice Act. So I do want to make that distinction right off the bat. As far as why there are currently issues, it's a multitude of issues. It is, first of all, because the current language is coming in from the pharmacy title rather than the Maryland Medical Practice Act, the standards for the permit are set to align with pharmacy permits, which are issued on 5-year terms. Meanwhile, physician licenses are on 2-year renewal terms. So what that ends up meaning is that there is frequently outdated information. By moving it to the Maryland Medical Practice Act, we could actually streamline that process and have it run on the same term as the physician license renewal. The physician license also has significantly stricter requirements for updating information, for instance, updating address information. When we did an audit of the inspections from 2014 through 2020 that the Office of Controlled Substance Administration had performed, we were finding that a significant percentage were coming back incomplete due to outdated information or incorrect information. That is an issue that we feel would be well resolved. The other issue, again, is the collection of evidence. Any board investigation, before we can proceed, the initial piece of that investigation is going to be collecting evidence to proceed. And again, that evidence collection piece is lacking. And then the final point I would make is that—
Briefly, Mr. Dudzik.
Yes, fair enough. The final point I would make is simply that, in the, over 8 years of having this authority, the Office of Controlled Substance Administration has never taken an independent action based on these dispensing permit inspections. And when we queried them about this, they were not aware of any instance where a dispensing permit inspection led to a referral to the Office of Attorney General Criminal Division.
And have you taken up any cases that could also be referred to you on over prescribing?
Yes, we—
In the last 5 years or 10 years, how many have you taken up?
We were able to identify 19 cases going back 2.5 years. Again, it's our search capacity is a little bit limited right now due to some network issues. So we had to pull these records manually, but we were able to, just in preparation for this hearing, we were able to pull 19 files.
And were critical action taken in any of those 19 cases?
Yes, those are 19 files that resulted in disciplinary action. We don't have an easy way right now to search through actions that did not result in charges that have been closed.
Thank you. Senator Lamb has a question, I believe.
Your earlier question was actually my question about how else can these be referred to, criminal prosecution if needed.
Okay.
No further questions.
Okay.
Thank you.
That concludes the hearing on Senator Lamb's first bill. Thank all the witnesses, and we will probably be getting back to many of you. Let us go to 355, HIV prevention drugs, prescribing and dispensing by pharmacists and insurance requirements. Senator Lamb.
All right, thank you, Chairman Pinsky. Here to present 355. For the record, Clarence Lamb, Senator in District 12. This bill is an updated version of bill that we introduced last year, which would allow pharmacists to dispense full courses of pre-exposure as well as post-exposure, so both pre and post-exposure prophylaxis without a prescription, without prioritization, and without step therapy, and without cost sharing for therapeutic courses, as well as the ancillary services that are needed to go along with these courses. The bill establishes guidelines, including a training program for pharmacists to ensure patient safety, as well as to post-encounter policies that will help facilitate connections for the individuals utilizing this to primary care providers, as well as Ryan White facility providers who specialize in HIV prevention care. So basically, this is for medications that can prevent people from getting HIV if they're taken before exposure or immediately after exposure. Despite the successes of antiviral medications, these types of medications to prevent the spread of HIV, HIV is still a major issue here in the state. In 2020 alone, there were over 30,000 people living with diagnosed HIV in Maryland, with 724 people newly diagnosed just that year. The year before, in 2019, Maryland was ranked 8th among states in the rate of new HIV diagnoses, and CDC estimates that there are over 3,800 people living in Maryland right now who have HIV and are undiagnosed. Fortunately, these medications that this bill authorizes pharmacists to dispense and prescribe are very effective at preventing the transmission of HIV. Pre-exposure prophylaxis is taken as a daily pill, according to the CDC, and pre-exposure prophylaxis, or PrEP, can reduce the risk of HIV transmission by as much as 99%. This bill authorizes pharmacists to prescribe and dispense up to 2 30-day prescriptions, or a total of 60 days of PrEP before subsequent refills requiring a physician's prescription. And post-exposure prophylaxis, or PEP, is also a daily oral medication regimen that if begun within 72 hours of potential exposure to HIV, it can reduce the HIV infection rate by around 80%. And a full course of PEP or post-exposure prophylaxis takes around 28 days, about a month. The main point of this bill is to make it easier for individuals to have access to these two medications that can prevent them from contracting HIV. And just want to underscore that while we still don't have a cure for HIV currently, we now have medications that if taken before exposure or immediately after can nearly always prevent someone from contracting HIV. And thus the intent of this bill is to authorize pharmacies to be an additional access point to these medications and remove barriers of cost, insurance, and prescription. Especially with PEP or post-exposure prophylaxis, meeting the 72-hour window following a possible exposure is critical and is important to be able to address any unnecessary barriers. Pharmacists are well-equipped health professionals who can serve in this capacity to help mitigate the spread of HIV in our communities by making PEP and PrEP more accessible. In terms of cost, this bill will lower financial hurdles to HIV treatment. This is because the U.S. Preventive Services Task Force issued a grade A recommendation for PrEP. And the task force grade A recommendations must be fully covered by insurance plans per the Affordable Care Act without any cost sharing. However, insurance plans are not required to cover the ancillary services that are needed to take PrEP. There are a few things that would normally occur for someone to be able to take PrEP, such as testing for HIV or tests for hepatitis. Those services would not be covered, but this bill would make that covered as well. So this creates, because those are not covered, it creates a barrier to access where patients can afford to get PrEP drugs, but they can't afford the associated care that's needed for them. This bill would cover those ancillary services, including kidney function testing, as well as those hepatitis tests I mentioned. Other states have already led the way on PrEP and PEP pharmacy access, including California, Colorado, and Oregon, allowing pharmacists to dispense both PrEP and PEP. Even before states pass this type of legislation, studies of pharmacy-based pilot programs in both Seattle and San Francisco show that these programs are safe, effective, and as well, and also financially sustainable. It's important to note that we did take into consideration patient safety, and as a result, we've written a number of provisions into this bill to help protect patients. The bill requires that all people initiating PrEP or PEP in a pharmacy setting have a negative HIV test to prevent treatment-resistant HIV, to prevent them from furthering HIV that's drug-resistant. It also requires that pharmacists provide referrals to providers for follow-up care and creates a training program for pharmacists to provide PrEP or PEP. Members of this committee may likely be familiar with scope of practice battles between different health occupations, and many of you know that as a physician, I'm not always on the side of pharmacists. So it may be a surprise to you that that my proponents on this bill are pharmacists, and those who have hesitation are physicians. This bill is not intended to wade into a scope battle, but the reason I'm introducing this bill is purely for the scientific, medical, and public health reasons. This bill is good public health, and this recognition has been accepted by other states, which is why we've moved this forward. I'm hoping that we are able to do so here because pharmacies are a safe and effective point of contact for patients to begin PrEP and PEP regimens. Reducing the barriers of cost and insurance will not only increase access to these life-saving medications, but also provide savings for our state Medicaid program in the long run, because the average lifetime cost for HIV treatment runs in the high tens of thousands of dollars. This bill makes good public health and financial sense, and for these reasons, I urge the committee to consider a favorable report on this bill. There is a sponsor amendment, which is mostly technical in nature, which helps clarify that a patient can be referred to a provider or a clinic, and that's on pages 5 or 6 of the bill. With that, let me turn it over to the sponsor panel. Thank you, Mr. Chairman.
Thank you, Senator Lamb. We'll start with Ian Bravo from Free State, lead witness, who will be followed by Beloe Akwakoku. And after we have 2 or 3 other witnesses who are favorable, we have a number who are favorable with amendment. I would encourage those people to spend most of your time on the amendment and show what you'd like to change in the bill. Then we'll go to the one oral testimony in opposition. So, Mr. Bravo.
Good afternoon. I am here in support of Senate Bill 355 on behalf of Free State Justice, Maryland's LGBTQ civil rights advocacy organization. Both PrEP and PEP almost always require a prescription through a primary care physician, as well as an insurance pre-authorization. In the case of PEP, which is used for individuals who have already been exposed to HIV, these delays can cause them to miss the crucial 72-hour window after HIV exposure for the drug to be effective. Senate Bill 355 ensures that Marylanders will not miss out on their own protection just because they are waiting on a decision from their insurers. This bill also greatly broadens accessibility to life-changing antiretroviral drugs to the populations that are most at risk for contracting and spreading HIV by reducing the barriers to receiving an initial prescription. Pharmacies are far more accessible compared to medical providers' offices and typically do not require appointments in advance, which is especially critical during that 72-hour window for PEP. There are significant protections to ensure that individuals are not being prescribed these drugs inappropriately, such as extensive mandatory counseling that would detail side effects, how to take the medicine, and the need for continued testing. This bill also requires proof of negative HIV status before an individual is prescribed the medication by either an HIV test done within the last 7 days or a rapid test. So by authorizing pharmacists to prescribe and dispense PEP and PrEP, Senate Bill 355 taps into the under-recognized potential of the pharmacist's role in HIV prevention and greatly contributes to public health by expanding PEP and PrEP's accessibility and reach to broader populations. So for these reasons, Free State Justice urges a favorable report on Senate Bill 355. Thank you, guys.
Thank you, Mr. Bravo. Ms. Akwakoku?
Good afternoon, everyone. This is
I apologize.
No problem at all, Mr. Chairman. For the record, my name is Bilal Akwakoku. I am from NCPA, the National Community Pharmacists Association, and I am here to speak in support of Senate Bill 355. As has been told earlier by by Senator Lamb and Ian Bravo from Free Justice, the pharmacies are widely accessible. 90% of Americans live within 5 miles of a pharmacy. Pharmacists do possess the proper training and credentials and disease state management dealing with chronic illness. The profession has grown from primarily dispensing and receiving reimbursement to slowly patient management and building patient relationships. We also, as a national organization, we've been advocating for other pharmacy administration bills of HIV, PEP, and PrEP in other states. This bill shares similar language in terms of the training program that is created by the Board of Pharmacy is done in consultation with other boards of medical professions, as well as giving proper guidance, as well as the proper number of hours for pharmacists to be trained in this administration. We understand that this bill will be widely accessible, will give accessible treatments, and we hope for a favorable report from this committee. Thank you.
Thank you. Let's go to Ms. Jordan. Welcome back, Ms. Jordan, to EHE. I don't know if this is your first return visit, but welcome.
I believe it is this session, Mr. Chair. Thank you very much. It's always lovely to get out of JPR. Mr. Chair, Madam Vice Chair, members of the committee, I'm Lisa Jordan with the Maryland
You're not
Coalition
alone in
Against-
making that statement.
I believe we have a club. Yes. I'm with the Maryland Coalition Against Sexual Assault. We're here in strong support of Senate Bill 355 and really to talk about two populations. For PrEP, sex trafficking and sex workers are often in need of PrEP, and the more access, the more community-based access we can have to PrEP, the greater number of sex workers who will have access to this medicine. So I'm here to say that MCASA supports the bill because of this, but also to say that the Maryland Human Trafficking Task Force is very much in support of this bill. This is also an extraordinarily important bill for rape survivors. You've already heard testimony that NPEP, so this is post-exposure medication, needs to be taken within 72 hours. There is already a program in the state of Maryland. In fact, there's a bill that Senator King has to lift the sunset on a bill that provides free NPEP to rape victims who present at hospitals and are seeking this medication. And I have the really horrific story for you of a woman who went to her physician. She was prescribed NPEP, and she was told that she could not get it because it was not pre-authorized. She was at the end of the 72-hour window, so she did not get the NPEP prior to the end of the window, and we don't know if she contracted HIV as a result of her rape or not. What's especially tragic to me about this is that the program we have in place makes using your insurance optional. So if she had simply declined to bill her insurance company, the state would have picked up the tab. This sort of barrier to access to NPEP is totally irresponsible, unacceptable. Senate Bill 355 goes a long way to increasing access. And for those reasons, the Maryland Coalition Against Sexual Assault and the Maryland Human Trafficking Task Force urge a favorable report.
Thank you, Ms. Jordan. Let's go to Mr. Tiffin, please. Scott Tiffin.
Thank you, Mr. Chair and members of the committee. My name is Scott Tiffin. I'm here on behalf of the Maryland Nurse Association and the American College of Nurse Midwives, the Maryland affiliate. We see pharmacists as a really good entry point to the PrEP and PEP process. And, the referrals that they would then do to full providers would be great. But I in particularly wanted to talk about the insurance parts of this bill. In 2019, the U.S. Preventative Service Task Force issued a decision that required all insurance companies to cover PrEP without any cost share. And at the time, there was a lot of conversation about whether that requirement would extend to all the ancillary services that are extremely important to accessing PrEP. And then later in 2021, the feds did issue an FAQ that did enumerate these ancillary services, saying that they also had to be covered without cost share, which was great. But when I had a conversation with the Maryland Insurance Administration, I was told that the administration did not believe they had the proper authority to enforce the cost sharing requirement on these ancillary services. So we just think this bill is a belts and suspenders type thing to make sure that Marylanders are protected and can access PrEP and PEP, without any cost share on the ancillary services. Finally, I know the insurers are concerned about the prohibition on prior authorization, but it's already been discussed. PrEP and PEP are extremely time sensitive, and any delay in accessing care greatly increases the risk that somebody will contract HIV. So I thank you for consideration of this important bill, and I'm happy to answer any questions.
Thank you, Mr. Tiffin. Let's go to Sarah Price, please, with the chain drugstores.
Thank you, Mr. Chair. Good afternoon, honorable members of the committee. My name is Sarah Price, and I'm here on behalf of the Maryland Association of Chain Drugstores, and we are generally supportive of this initiative. I would first like to thank Senator Lamb for bringing this issue back this year. When we come before you on bills like this that would impact scope of practice, it is with the intention of expanding access to care for patients who are currently not able to get the medical attention that they need. If passed, as noted, this bill would have a very positive impact on community health for some of Maryland's most vulnerable populations. You have our written testimony, and we actually have met with Senator Lamb's office before session began to discuss our position on this bill. So I'll just briefly highlight some concerns that we have regarding how the bill as drafted could prevent some patients from receiving care. We understand that certain limitations were included in the bill with the ultimate goal of connecting patients with a physician, but the restrictions in the bill can't actually stop individuals from pharmacy shopping, and it could keep patients who do not have and refuse to seek out a physician from receiving continued treatment from a consistent documented source. Additionally, pharmacists can't force a patient to accept counseling on a medication. And though we do understand the importance of making sure that patients understand that all aspects of the treatment that they're receiving. We're concerned about the future impact of setting a precedent for restricting care based on a consultation requirement. And this could also be an issue if the restriction on prescribing more than a 60-day supply of PrEP in 2 years is removed. Ultimately, though, 12 other states, including our neighbor Virginia, have already authorized their pharmacists to provide this care, and we strongly agree with the sponsor that pharmacists are capable of performing this service. We would just ask that you consider our recommendations and ultimately allow pharmacies to bring this preventative treatment to their communities. Thank you.
Thank you. I assume, Ms. Price, your amendment is included in your testimony?
Yes.
Okay, let's go to Ms. Abraham, please.
Good afternoon, everyone. Thank you to the chair and all members of the committee for allowing me to be here today. I am Lindsay Abraham from the National Association of Chain Drug Stores. I am also a pharmacist by trade, licensed both in the state of Maryland and Virginia. I was born and raised in Maryland, so I recognize and appreciate the state's focus of placing at the forefront through bills like this that will broaden access to care. And I appreciate the opportunity to testify in favor of Senate Bill 355 regarding pharmacists' ability to provide these HIV prevention services. I would just like to note that pharmacies are not only noted as one of the most accessible healthcare destinations within the community, but pharmacists are trusted by patients to provide that safe and quality care. I graduated from the University of Maryland Eastern Shore School of Pharmacy, so I can personally attest to the fact that pharmacists undergo a comprehensive doctorate program, which covers various medication and patient care aspects that prime them well to provide this service. So that would include identifying at-risk patients, conducting point-of-care testing, providing the relevant therapy when appropriate. And as medication experts, pharmacists are capable of identifying and managing side effects and can provide the necessary counseling, especially as patients visit their pharmacist pretty frequently. So on top of this extensive educational background, pharmacists are fully capable of adhering to the standard protocols and procedures that any other healthcare professional that's qualified to provide this service would usually adhere to as well. Pharmacists have the ability to connect patients with other healthcare providers when necessary, and they can refer them to the appropriate care, especially for those who don't have a primary care provider. So as Senator Lamb had mentioned earlier, there are quite a few that are diagnosed with HIV. And on top of that, the estimated amount of 10% that were undiagnosed. So if this bill were to be passed, Marylanders could then go to any of the 800 pharmacy locations in the state to get that timely care that they deserve. So once again, I appreciate the opportunity to testify in favor of Senate Bill 355, and it would provide broader access to HIV prevention services. Thank you to the committee, and thank you to Senator Lamb for sponsoring this bill, and I'm more than happy to answer any questions when appropriate.
Thank you, Ms. Abraham. We'll go to the final proponent and then the one opponent. I forgot to mention, I apologize. We've been joined by Senator Klausmeier from Finance, who has some overlapping health and insurance issues with us, and she's worked for many years on overuse of opioids and other drugs. So welcome, and when we get to questions, Senator Klausmeier, please feel free to join us in asking questions. Okay, let's go to Brad McElya from Walgreens.
Hi, distinguished members of this committee. My name is Brad McElya, pharmacist and director of specialty health solutions for Walgreens. As previously described, I think that this bill really is about increasing access. A few key statistics for you. Despite extensive efforts from the federal government, 1 in 7 individuals living with HIV in the United States still does not know that they're living with HIV. That's 14% of people currently living with HIV does not know their HIV status. In addition, only 18% of individuals that could be taking pre-exposure prophylaxis or PrEP to prevent HIV acquisition are actually utilizing PrEP services. I would argue that these statistics are astounding because life-saving and preventative services have been made available, but must be more accessible. As mentioned by my colleagues, I believe that pharmacists can really serve as that entry point for patients to access life-saving preventative services. I want to highlight some efforts that we've been able to do at Walgreens, one of the states where we have a pharmacist-based HIV testing program. nearly 50% of the individuals that had free HIV tests used that service after traditional business hours. And lastly, one of the things is, I know many things have already been mentioned, I did want to describe that whenever a patient does test positive for HIV, we can serve as a critical resource in helping to link that patient to long-going care. As one of the things that is not included in this is for pharmacists to be able to provide antiretroviral virals for patients that are living with HIV, but instead we can serve as a linkage to care the patient once they know their HIV status. I do want to thank you for your consideration of this bill and for your time.
Thank you. That concludes our proponents. I don't see any questions, but I'm happy to entertain them. Then we will go to our opponent list, and that is Neil Karkanis with Legal Life and Health Insurers.
Good afternoon, Chair Pinsky and members of the Education, Health, and Environmental Affairs Committee. For the record, Neil Karkanis here on behalf of the League of Life and Health Insurers, who's in respectful opposition to Senate Bill 355. I also know that Kaiser Permanente is in opposition, and they submitted a letter to that effect. But we do support Senator Lamb and understand what he's trying to accomplish here. We support PrEP and PEP, so there's certainly no debate about the value of these medications, but unfortunately we can't support the bill as introduced. With regards to cost sharing, just to be clear, there might be an existing funding source to help defray some of these insurance costs associated with PrEP for high-risk HIV-negative individuals. In 2016, the Maryland Department of Health had a departmental bill that created a special fund called the Maryland AIDS Drug Assistance Program, otherwise known as MADAP. MADAP would fund services associated with the state's HIV/AIDS-related priorities, such as prevention, surveillance, and care services. And at that time, DLS estimated that a one-time general fund expenditure of $100,000 would generate about $3.7 million in rebates by 2021. There also happens to be a bill this session that you all already passed, Senate Bill 186, that addressed an issue with the fund itself. But that bill has already passed unanimously out of the Senate and it's being heard in the House. But in its fiscal note, DLS noted that a result of an Office of Legislative Audits report in fiscal 2017 through 2019, MDH did not submit some certain MDAP drug utilization data to manufacturers, which ultimately resulted in untimely collection of approximately $20.6 million in rebates, including lost investment income, including approximately $187,800. There was also untimely rebate requests and payments that essentially resulted in lack of pursuit of roughly $7.3 million. The whole point of me bringing this up is that there are significant dollars available in the MADAP fund that could be utilized for the purpose of Senate Bill 355. And I think it's critical that the General Assembly first understands whether the special fund is adequately covering the cost of PrEP for eligible Marylanders, and whether that might help offset this cost sharing requirement. Additionally, the utilization review currently available, it's an important control that helps ensure that we keep the cost of drugs down. Without the utilization review component, we can't make sure that we're choosing the more cost-effective, perhaps generic drugs. So for those reasons, we respectfully urge an unfavorable report on 355, but happy to speak with the sponsor and try to work these issues out.
Senator Lamb.
Thank you, Mr. Chairman. So a question for Mr. Karkanis, who represents, I guess, some of the payers. So my understanding is that the feds have issued guidance that so PrEP itself should be covered because it's grade A under U.S. Preventive Services Task Force. So one, if you can assure us that all of your payers, all the insurance companies are covering PrEP without cost sharing, as is required by the ACA. And number two, there was guidance from the feds that ancillary services also should be covered as well as part of that recommendation, and that was verified with the Maryland Insurance Administration. Are the insurance companies fully covering PrEP without copay, as well as any of the ancillary services?
It's a good question, Senator. I'd certainly need to check with each individual carrier. But as you know, any cost sharing requirements that are medically necessary and appropriate are required to be covered. But I'm happy to go back and find out.
Okay, because I think PrEP should be fully covered already per the ACA, and with that guidance, the ancillary services should be as well. And then when you brought up, I think that's MDAP, right? The state
Yes.
program.
Mhm.
Are there enough funds in the state program to support everyone who's not able to cover their ancillary services or the copays that are involved with that in PrEP?
I think that's a good question. I mean, that's exactly what I'm saying we should explore. You know, first of all, we're finding out that the state was essentially losing out on some of those rebate dollars. And now they're going to be correcting that through the bill you passed. And hopefully the House will pass it as well. But that's the very question. Will the funding that's already available through this special fund be adequate for the folks that need the assistance? And if so, then we should be able to, I think, adjust this bill accordingly.
Well, I'm guessing that you and I know the answer to that question, which is that MDAP can't support all those who need the funds. And so your contention that the state should be able to support all those who may be indigent and not be able to afford the copays doesn't fully solve the problem. And that's why we're turning to the insurers to help with this.
Yeah, I think we need to get a clear answer on that question. I just don't know, Senator, to be honest with you.
Okay. All right. Thank you. Back to you, Mr. Chairman.
Okay, that concludes the hearing on Senator Lamb's second bill and final bill of the day. We're going to move to Senate Bill 311, Senator Riley, and I am going to, it's health occupations, podiatric physicians, and I am going to shift chairing back to the vice chair. Senator Riley, welcome.
Thank you very much, Mr. Chairman, and good afternoon, Madam Vice Chair.
Hello.
An interesting bill that has been before us several times. This bill passed the House in the 2020 session and 2021 session. It has come over to the Senate and no action has been taken. It is a turf war. When I joined Senator Pinsky in 2010 session, the first thing they told me was about the turf wars, the podiatric doctors versus the orthopedic surgeons. Where on the foot, where on the leg does one stop and the other stop? The current law says that the podiatric physicians treat the human foot or ankle, the anatomical structures that are attached to the foot, or the soft tissue below mid-calf. And ladies and gentlemen, we're not touching that. That's established. No big problem. The question is, what type of respect do we offer to the podiatric physicians? And I use that term very, very specifically. In Maryland, MedChi and a lot of the MDs and ODs would like to refer to podiatric physicians as doctors of podiatric medicine. The interesting thing is, to qualify for a license to practice podiatry, among other requirements, an applicant must be a graduate of a school or college of podiatry, which is accredited by the Council of Education of the American Podiatric Medical Association. And is approved by a board. The applicant must also pass an examination given by the board. According to the American Association of Colleges of Podiatric Medicine, a podiatrist is the doctor of podiatric medicine and is also referred to as a podiatric physician or podiatric surgeons. Podiatrists are defined as physicians by the federal government. Doctors of podiatric medicine are specialists in the prevention, diagnosis, and treatment of lower extremity disorders, diseases, and injuries within the profession. And these doctors can specialize in areas of surgery, orthopedics, and public health. This bill would change labeling throughout the Maryland Code, whether it be the annotated code, regulation, rule, executive order, law. It provides recognition for their training and experience and makes it uniform with the federal government and many other states. And I have a panel of expert witnesses who will talk about this. This is not to take away anything from any other medical group. This is an opportunity to recognize standard practice in hospitals and to give them the proper designations which they've earned over the past many decades. That concludes my testimony, Madam Vice Chair, and it's up to you.
Thank you, Senator Riley. I wonder if this turf battle is synthetic turf or other kinds of turf. We're about to find out. Your lead witness is Richard Block, who's back with us again. Mr. Block, the Maryland Podiatric Medical Association. Welcome back to EHE.
Actually, Madam Vice Chair, thank you. Dr. Adam Lowy should be the first speaker as the sponsor, on behalf of the sponsor.
Happy to have him. That's not the way it's marked, but we're happy to welcome Adam Lowy as our, there we go. Dr. Lowy, welcome.
Thank you, Chair, Vice Chair, members of the committee. Welcome everybody this afternoon. I first off want to thank Senator Riley for his support of our bill. This is Senate Bill 311, asking for a favorable support. This bill is currently cross-filed in the House as House Bill 790, and last year was Senate Bill 169. I'm going to go over a couple of key points that Senator Riley had already mentioned. This is not a scope war. This is not a scope bill. We're kind of laying that issue to rest. In terms of the summary, the best summary of our bill is our fiscal responsibility. That gives us essentially the detailed outline that says we're just changing our name in the books from podiatrist to podiatric physician. Couple of things that I want to highlight is physician title should really be kept of the highest standards in education. And 91% of people that took a survey by the AMA found that education, medical schooling, and training are vital to optimal patient care. Podiatrists currently have a 4-4-3 model of their education and training. And similar to what Senator Riley was saying, that is 4 years of undergraduate, 4 years of a medical schooling training, and 3 years of a hospital-based surgical and medical residency. Medical school has a similar 4-4-3 model for similar doctors, such as emergency room doctors, pediatricians, and general practitioners. Those are MDs and DOs that have the same 4-4-3 model training. When it comes to practicing in the state of Maryland, an MD or a DO is only required to have 1 year of postgraduate training in order to practice medicine. Podiatry requires 2 years. And with the standardization of all of our schools, now everyone that comes out has 3 years mandatory training. That 4-4-3 model maintains that highest caliber of education and training in the state of Maryland. There are 36 other states in the country that have, in some verbiage, the term physician in our title. 23 of them are podiatric physicians, the far majority. 8 of them, physician who practices podiatric medicine, a little bit lengthy on that, and 5 are physicians of the foot and ankle. We're talking about a nuance of terms that has been discussed in the past. In previous testimonies in previous years, our opponents have said, you know, this word has real meaning to our members, okay? It's their identity. But of course, they have no objection to physician being in the title of a physician's assistant, which clearly is broad acceptance in our medical community, okay? Physician's assistants, by the way, have only 2 years, a 4-2 model, 4 years of undergraduate and 2 years of education. So there's a clear difference as to our higher level of training and education that we have. Our opponents still do not understand our education. And we know that because of previous testimonies in the last several years. They are mentioning things that are untrue in terms of our classes, our external rotations in the 3rd and 4th year of school, as even our residency training and what that consists of, okay? Podiatrists are considered physicians to the federal government. During the coronavirus pandemic, the Department of Homeland Security deemed physicians as critical care workers. The federal government, Department of Homeland Security, MDs, DOs, doctors of podiatric medicine were included in that, okay? There is confusion from what they are saying that the public does not understand. The hospitals understand. I'm a physician according to the hospital, okay? On a national level, okay, and it's been talked in the past that there has been a joint task force with our national association on trying to standardize this. The attempt was to get us access, podiatrist access to the USMLE, which is what MDs take. The board, the governing agency that manages the USMLE rejected our request to sit for the exam. We are considered podiatric physicians in multiple areas of the state.
Dr.
So
Lowy,
that-
your time has expired.
Thank you for your support.
We appreciate your being here. Now, Richard Block, can we call on you now? You good?
Actually, I'll go, I can go ahead, but
Clean
Dr.
up.
Martirana
All
is
right.
supposed to be listed second.
All right. No, we have.
I'll be cleanup.
Vincent Monterana. I like cleanup. I get it. The Maryland Podiatric Medical Association. Dr. Maturana, welcome.
Thank you. Welcome. Greetings and thank you for the opportunity, Madam Chair Kagan and Chair Pinsky and members of the committee. My name is Dr. Vincent Martirana, and I've had the great privilege of practicing podiatric medicine and surgery in our wonderful state of Maryland since 1978. As a medical professional, we serve side by side with our MD and DO colleagues, not only at bedside providing patient care, but also on hospital committees. In fact, it was an orthopedic surgeon that actually nominated me to the Medical Executive Committee. That same surgeon recommended that podiatric surgery be a section independent of orthopedic and general surgery. Frankly, I've never felt that I was considered anything other than a podiatric physician. I'd like to share with you some of the roles that we play in addition to providing patient care. Kindly take note of how many times I use the word physician. We serve as physician members of hospital medical executive committees. Our physician colleagues have elected us to serve as their medical staff president or chief of staff. We also serve as physician chairs and physician members on virtually every hospital committee, including committees that oversee peer-reviewed disciplinary actions and the granting and removal of privileges for physicians and allied health professionals. There are physician members on hospital boards, directors, and how about this? It was a podiatrist that was the first physician board chair at one of the state's major health systems hospitals. In fact, one of our members is current chair of the Department of Surgery and oversees all surgical specialists. Last year, one of my MD colleagues sent me a copy of MedChi's end of session update newsletter MedChi sends out to its membership. After reading this, I was quite disturbed and understand, frankly, why MD and DO physicians would be opposed to the change of our designation. I'd like to read it word for word for you. Podiatry bill. We killed a measure in the Senate that would have allowed podiatrists to call themselves physicians. This victory is particularly gratifying, given that the federal government and 36 other states allowed this to occur. This characterization is grossly misleading to their membership. We never asked to be referred to as physicians, but rather podiatric physicians. Kindly take note of the letters of support provided by our physician colleagues and hospital administrators. We respectfully request this committee to approve the change in designation of podiatrist to podiatric physician so as to better reflect for the public our education, training, and experience. Thank you so much for your time. 1 second left.
Yes, woohoo. Dr. Maturana, thank you very much. Okay, Richard Block, may I please call on you now?
Thank you very much, Madam Vice Chair, and thank you, Mr. Chair and the members of the committee. I am Richard Block. I'm the Executive Director and General Counsel of the Maryland Podiatric Medical Association, and I've been in one or more of those positions since 1979. This is a bill that does nothing more, has been stated, than changes the definition of a DPM and changes the name to podiatric physician. It was overwhelmingly approved in the House for the past couple of years. we would respectfully request that it be passed by this committee and given the vote in the Senate. This does not change anything. The only surgical profession in medicine other than MDs, DOs, and DDSs are DPMs. They are surgeons of the foot and ankle and the lower leg. The definition of both physician under the health occupations article in 14102 and the definition of podiatry in 16102 are virtually identical. They use different phrasing, but they all are almost identical in this General Assembly's enactment of their practice. They diagnose, treat, prescribe in their respective areas. The difference is only that MDs are generically licensed and they self-designate. Podiatrists and podiatric physicians go into podiatry medical school with the intent of becoming a specialist in their conclusions. I respectfully request that you favorably report this bill. Thank you.
Thank you, Mr. Block, and thank you for a lot of service, keeping us on our toes. Oh, that was bad. Okay. We have unfavorable witnesses. Bruce Bariano is leading off. Mr. Bariano, twice in 1 week. Welcome back. Today you are with the Maryland Eye Society of Physicians and Surgeons. Welcome to EHE.
Good afternoon, Madam Vice Chair and members of the committee. For the record, Bruce Bariano, here on behalf of the Maryland Eye Physicians and Surgeons in opposition to this legislation. There's no benefit to this bill to the public at all. The public will not be properly notified. They will be, frankly, deceived that they think they'll be dealing with a physician by using that term, and they will not be dealing with a physician. They will not be dealing with a person who is a graduate of a medical school. The witness that used the phrase physician's assistant, the word physician in that term is just to identify what the assistant does. The assistant assists the physician. So the public is not benefited at all by the passage of this legislation, just the practitioners, podiatrists, as they practice their profession and gainful employment. So since there is no public benefit to this term, there's no need to change the law, and I would urge an unfavorable report. Thank you very much.
Thank you, Mr. Bariano. Also testifying against this bill is Laura Lee Ma from MedChi. Ms. Ma.
Thank you. I just want to make sure you guys could hear me. Thank you, Vice Chair Kagan and Chair Pinsky and all the members of the committee for hearing me. I'm Laura Lee Ma. I'm the president of MedChi this year, and I'm a practicing community physician in the counties surrounding Baltimore. I'm attesting in opposition to Senate Bill 311. Patients really do understand the title of a physician to be an MD or a DO. To give this term to other providers confuses the training and level of practice of healthcare of providers other than MDs and DOs. A physician has historically been defined as one who is trained in the anatomy, physiology, pathophysiology, health and treatment of the entire patient. After completing a bachelor's degree, the 4 years, an MD or DO completes another 4 years of medical school, which begins with anatomy and physiology of the entire patient. And then in the second year, pathophysiology, so the conditions, and performance of the physical examination. Pharmacology begins this year as well, and differential diagnosis. In years 3 and 4, the clinical rotations begin in full force and include pediatrics, family practice, internal medicine, and surgery. After obtaining an MD, physicians, MDs, perform a year of internship, either in internal medicine, surgery, or a transition year, which is a mixture where they go through some of the surgical and medical specialties if they're doing something that's going to end up where they do more different things, right? Where they do some surgical things as well. And again, they treat the patient as a whole. Only after this rigorous training in caring for the entire patient Specialty training and residency begins for 3 to 5 years and therefore often another 1 to 2 years of fellowship. My daughter just finished her MD at the University of Maryland Medical School this last May, magna cum laude, I would say, and is now doing her transition year at the University of Maryland Midtown. Having seen, I mean, honestly, she's living here, she's coming home, treating COVID patients, you know, having to talk to families, treating patients in renal failure and diffuse coagulation where they're blood clotting everywhere. It's made me even feel stronger that this training is unique and it is the whole body. She's treating stroke patients, heart patients, you know, renal failure patients, an amazing amount in 1 year, probably 2 or 3 years really worth of learning in that 1 year. In this era of COVID and in public health emergencies to come, medical students were graduated early. Surgeons did go to work in emergency rooms and ICUs, and my anesthesia colleagues went from their ambulatory care surgeries to work in ICUs. And radiologists even went to do that. But on behalf of MedChi, I'm asking you to vote to reserve the title position for those who are rigorously trained in evaluating the entire patient. Thank you.
Thank you, and congratulations to your daughter and your whole family. You're proud. You must be very proud. Thank you. That concludes the testimony. I see no questions on this bill, which, as Senator Riley indicated, we've seen before. So that completes the hearing on Senate Bill 311. We still have 2 bills left, colleagues, and then we will be coming together to vote. So the next bill, we have Senator Watson in the room for Senate Bill 555. Senator Watson, Occupational Licensing Board and Commission on Judicial Disabilities, reporting disciplinary activities. Senator
Thank
Watson,
you.
welcome back.
Thank you. Thank you, Vice Chair Kagan. Good to see members of the committee. Senate Bill 555 is a bill that requires the Business and Health Occupations Board to include information on the gender, race, county of practice, type of disciplinary action imposed, length of disciplinary period, and the amount of fine imposed in any annual report on disciplinary activity issued by the board. This bill seeks to gather this data, gender, race, and location data regarding disciplinary actions taken by various occupation boards in an effort to ensure that equitable punishments are handed down by these boards. It is voluntary for an individual to provide this data, and the data is anonymous. In order to prevent bias or discrimination in disciplinary actions, we must ensure egalitarian practices. Senate Bill 555 is a positive step towards this goal. The impetus of this bill is the result of me receiving over 2 years worth of emails, phone calls from practicing attorneys, which suggest bias, particularly with respect to solo law firms, as well as minority attorneys, from the perspective of dealing with the consequences of bar counsel and attorney grievance commission. And the question is, how can we track potential causes of racial and gender-based biases and discrimination if the data is not recorded, collected, and made available? The bottom line is we need to collect the data, analyze the data, and ensure that there are no potential disparities that are found in this analysis. I'd just like to emphasize we can't tackle the issue if there's no data to study it in an effort to provide evidence-based solution. Senate Bill 555 will start that process. And for these reasons, I respectfully urge a favorable report. I will add that there is an amendment coming which will strike the provisions of this bill to the Commission on Judicial Disabilities. And the reason is the separation of powers and the fact that the Commission on Judicial Disabilities falls under the auspices of the Court of Appeals and don't constitute disciplinary activities of the Commission. With that being said, I urge a favorable report. Thank you.
Thank you, Senator Watson. Your lead witness is Valeria Tomlin from Tomlin Law Office. Ms. Tomlin, are you in the room?
I don't see her.
I don't either. Let's see if you can try to reach her, Tanya, while we see if we can hear from Carolyn Elephant. Carolyn Elephant, I do see you. So you would get 2.5 minutes in the event that Ms. Tomlin will be coming to join us. Welcome, Ms. Elephant. You may begin your testimony.
Thank you. My name is Carolyn Elephant. I'm a member of the Maryland Bar, the owner of my own small law firm, and publisher of myshingle.com, a national blog dedicated to celebrating and empowering solo and small law firm owners. Thank you for the opportunity to testify today in support of Senate Bill 555, which among other things would collect data on the gender and race of lawyers who are the subject of disciplinary actions by Maryland licensing boards. According to the American Bar Association data, roughly 50% of lawyers are solo practitioners who serve the legal needs of ordinary.
She's supposed to be on a Zoom.
Excuse me, Ms. Elephant. Tanya, could you please mute yourself? Thank you. I'm sorry, Ms. Elephant. Please continue your
No
testimony.
problem. I was just saying the data shows that 50% of attorneys are solo practitioners who serve the legal needs of ordinary people. And in recent years, an increasing number of women and lawyers of color have chosen to launch their own law practices in response to the pervasive glass ceilings and discrimination that stymie their advancement at large firms. Yet in spite of the critical role that solo and small law firm practice plays in ensuring access to justice and diversity within the legal profession, studies from other state bars and by university professors show that solo lawyers and lawyers of color are disproportionately targeted for discipline by grievance committees. Through my blog, I've been made aware of strong anecdotal evidence that Maryland's disciplinary boards have likewise disproportionately targeted and punished solo lawyers and lawyers of color. Senate Bill 555 is a benign first step that would enable the legal profession and the public we serve to evaluate the nature and extent of institutional bias. In addition to collecting data on race and gender, I would also propose gathering information on a lawyer's firm size as well. As the saying goes, we cannot manage what we do not measure. To vote against this bill would be to vote to remain in the dark about racism and bias in the institutions that regulate Maryland lawyers, instead of taking steps to shine a light on these practices and to improve our institutions. I've submitted written testimony on this bill, and it contains supporting references to some of the data and statistics that I've quoted. Thank you very much for this opportunity to testify today.
Thank you, Ms. Elephant. And I do not see Ms. Tomlin in the room, but Senator Watson, I think Ms. Elephant did a very good job on your behalf. There's also written testimony from MedChi in support. The Maryland Judiciary was against, and so was the Department of Health.
Excuse me.
Yes.
They should have written testimony for her.
Yeah, she was supposed to be testifying orally, is what it says in the sign up.
Okay.
So, okay, all right.
Okay.
Since she is not here, unfortunately, that concludes the hearing. I see no questions from colleagues. So Senate Bill 555, Senator Watson, thank you for being with us. Thank you for this bill. And we are on the last bill of the day. That is going to be Senate Bill 608. Senator Zucker, I see you in the room. Welcome. Report on the public or private conversion of state property to affordable housing. Welcome, Senator Zucker.
Madam Vice Chair, it's great to see you. Mr. Chairman, distinguished members of the Education, Health, and Environmental Affairs Committee. I understand I'm the last bill of the day before voting, so I will be concise in deference to your valuable time. Senate Bill 608 is the cross-filed Delegate Pam Queen's bill. I want to commend Delegate Queen for her efforts around the affordable housing market. I'm here today partnered with the Maryland State Realtors to acknowledge that we have a housing crisis and we need to get a better idea of what's happening out there. So Senate Bill 608 would require the Department of Planning, Department of General Services, in coordination with the Department of Housing and Community Development, to get an inventory of state land and report to the General Assembly on their findings. Right now, as the Maryland Realtors have pointed out in their written testimony, right now we're short about 82,000 housing units. So this will help us give us a path for the future. Madam Vice Chair, in respect to your time, I'd ask most of my witnesses, if not all of them, to do written testimony. There's no fiscal note. I believe there's no opposition, and I would ask for a favorable report on Senate Bill 608. Thank you.
Thank you, Senator Zucker. Thank you for your consideration. The Maryland Realtors, the Maryland Affordable Housing Coalition, the Maryland Building Industry Association, and AIA Maryland, which is the American Institute of Architects, all submitted written testimony. Colleagues, there was no opposition. Are there any questions for Senator Zucker? Seeing none, that completes the hearing on Senate Bill 608. Short and sweet. Thank you, Senator Zucker. That completes the hearings for the day, but I'm going to toss it to the chairman, who's going to announce our plan for voting session.
Thank you, Vice Chair. Thank all of the witnesses and people who stayed and the patience they showed in today's hearing. It is now 4:05. Let's make it 4:30. If people will take is that too long, or if people want to start sooner?
4:30 sounds like a vacation.
4:30 promptly in the hearing room, and bring your files if you need them, or your computer and your voting list.
And if you'd like to come down a few minutes early to celebrate Senator Gallion, is that all right, Senator Pinsky? Can we do that a few minutes beforehand?
Sure.
So if you want to come down at 4:20, 4:25, and since we didn't get any of the cake, we've got something to share here for Senator Gallion.
Great.
Hey.
Thank you. We're adjourned. I'll see